me from my winter hell. I've got candles and candy, I can be your daddy if you only let me creep into your prison cell. Hey baby, can you tell I'm not a criminal? Your choice is seminal. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. Just speak low, stand in your row, try not to show this life's a show. Try not to glow way down below. Oh, it's a lot of woe, and that's not a place where you would like to go. I've got cigarettes and brandy, which could come in handy if you just help me loosen up my hand grenades fuse. Baby, don't refuse my truth, but it's up to you now to choose. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true, 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 true.
Hey guys, good morning. It's Friday. Yay, it's Friday. We made it to the end of the week and the first day of the defense's case in chief. What do you think, guys? How do you think they're going to do? I believe the first witness is going to be biomechanics. That's what. Hold on a second. I don't know what I'm doing. That's what Tess sent me the CV of the parent first witness yesterday. Which shout out to Tess. Thanks, babe. But yeah. So let's see how they do. Also, for lunch today, we will be lunching with Lori because, oh my God, yesterday she had her final pretrial hearing before her her trial starts, and it went, as you would expect, because it's Lori. It was a mess. My favorite part was the fact that Lori tried to talk to the judge and ask the judge questions as if she didn't just file a motion to have him recused and accuse him of judicial misconduct. So there was that. So during lunch today, we will visit with Lori and see how that went. And also, I wanted to tell you guys, for scheduling purposes, I want to stream both trials, okay? Because I'm committed to Karen and I'm committed to seeing this through with Lori. This is Brandon Boudreaux's the trial for the attempted murder of Brandon Boudreaux is unique. Brandon Boudreaux is the only victim of Lori Vallow Daybell Esquire and Chad Daybell that survived. Everybody else did not. So it will be a different kind of trial. So what I want to do is stream Karen in the morning, okay? And I think the way the judge is going to do the trial is that it will start like it did last year or last trial at 10 o'clock their time, which is noon Central, 1 Eastern, and then it'll be 4 days a week. They're off on Friday, and then there's like a whole week where they're not even having trial. So as soon as Karen Reed ends, because her trial ends for me at 3 Central, 4 Eastern. So we'll just be a little bit behind because there's going to be a delay too. So we'll only be a little bit behind. And then that way we can skip through. So that's what we'll do. I'll just bing, bang, boom. That'll be that. All right. So let me say good morning to you guys. Good morning, Kelly. Good morning, Julie A. Good morning, Lil D. Good morning, Neat Noodle. Good morning, Sarah Bellum. Good to see you. Good morning, Violet. Good morning, Chief. Good to see you. Good morning, non-blonde millennial. Rachel Lee. Good morning. Good morning, Claudia. Good morning, Melissa. Good morning. Good morning, Sissy's mom, Jen. Good to see you. All right. I hope you guys had a great night yesterday. Now today, okay, I'm hoping that Judge Bev sticks to a tight schedule because it is Friday and we all know how Judge Bev likes to roll on the Fridays, because I do need to be done today. I got errands I got to run, and I'm going to go. I'm going with my little Chicky Nugget Pot Pie Esquire, so I don't want to be late. I might have to cut the trial short and stop streaming like at 2 Central. I don't know. I'm going to text my. I should be fine though, so we'll just play it by ear just to give you guys a heads up. But I intend to go all day today. Also, I'm trying to plan this charity streams, fundraiser stream to benefit the National Center for Missing and Exploited Children. I wanted to do it tonight, right? But I really, really want Melissa Jade to be able to be there, and she's really busy. So I think I might do it maybe next Friday. I also wanted to do it because today, guess what today is, you guys? Apparently, according to Sissy's mom, Jen, it's National Jennifer Day. So woohoo! I kind of wanted to do it today because of that too. I just thought it'd be kind of funny and kind of cool, but I really want Melissa to be there. And I know she's super busy this week with her channel plus real life. So I'm going to wait. And oh no, I'm sorry, Sissy's mom. Sissy's mom says got bad news yesterday. So I'm glad I don't have to hear Brennan first thing. We're all glad we don't have to hear Brennan first thing. Brennan, no me gusta. And I'm really curious about the tone Brennan is going to take. Now, we haven't seen him we've seen him cross-examine somewhat. Remember Aka, or as he says, Arker, during their voir dire. So we've kind of seen a little bit of his cross-examination, but I want to see his like actual cross-examination technique in front of the jury. So that's what I'm interested in seeing today. And I'm interested in the first witness. And I think this part for Karen has got to be the most nerve-wracking. This is, after all, her case in chief. And, I think she kind of knew what to expect having gone through the first trial with the state and then the second. I mean, they left out some people, obviously. There were some notable absences this time around, but I think this will I think this is going to be the most nerve wracking for her. It would be for me. If I were a defendant, putting on my case would be the most nerve wracking. I think it would be the most difficult. Also, um, there is Allie is doing Alex Erickson. She's doing a charity stream on Sunday, and she asked me to come up. So I'll be doing that Sunday evening. Um, what else? What else? What else? What else? What else? Donna Adelson's pulling some shenanigans ahead of her trial as well. And I need to get caught up on all of that stuff so that I can talk to you guys about it because her trial is coming up. Stephen Stern's first trial, I can't even believe it, even though it was pushed back the trial date. I'm thinking they're thinking July. So we're going to be busy over here at the ward. We'll have plenty of stuff to keep us, plenty of trials to keep us, you know, not, to keep us busy. So it's going to be busy, but I like being busy. So that's good. Yeah, neat noodle, me too. I do love some good shenanigans. And, Donna Adelson, she, she tried when she got up there and testified a few months ago about what it's like for her being in jail. And, she tried to, come across as really, it's just this, this little old lady, and, poor her. And, she's being railroaded, blah, 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 blah. The real people that murdered Dan Markel, who, by the way, she's saying that it's that Catherine McBanwell basically is, the one that's running the show and whatnot and just railroaded her family. Okay, Donna, I'm going to need you to sit down and shush on that. Okay. I mean, keep saying it if you want to, but I feel like you should really go back and listen to it objectively. They, they didn't benefit in any way, shape, or form from murdering Dan Markel, but you did. And so did Wendy. Stop playing with these people, Donna. So yes, Rachel, Lori is giving everyone a run for their money. I mean, y'all, just wait till lunch. Just wait. I was watching it last night, and because they don't stream the proceedings live. They're recorded, and then they can be uploaded and streamed live after they've ended. And there were so many times, and Lori claiming that the judge's facial expressions and whatever is evidence of him being biased. Which, by the way, speaking of bias, that's the theme of the jury selection. Basically, Lori is dismissing people left and right because of bias. Lori, you keep using that word. I do not think it means what you think it means, ma'am. Okay? So it is what it is. She was out of control. She was rude yesterday. I mean, she was everything that she normally is. Uh,
Thank you.
no clue.
So I was told counsel wanted to.
Oh, why is it? I really don't like that. Oh my God. Just stay. All right. All right. We've got our first sidebar of the morning. But yeah. Hey, I'm Kayleen. Good morning. Good morning. Good morning. Hold on a minute. Melissa says when she told that female judge nope was funny. She tried and didn't get her way still. Yeah, I mean, people were asking yesterday about like Judge Bev and what could be done about her. And the fact of the matter is, okay, as much as this pains me to say it, Lori did it, went about exercising went about getting an attempt to get a judge recused or admonished or, whatnot. She did that the right way. As much as that pains me to say, she did. That's the way you do it. She just hers didn't have any merit at all. So there's that. Good morning, Tess. Good to see you, babe. It's just, okay. Was that other hearing the hearing that she had, respective to getting Judge Boreski recused and sanctioned and cited and punished, and she wanted all the things. Was that hearing streamed? I'll have to look. If it was, oh gosh, I know what my weekend's gonna be. She's out of control. So they're doing another day today of jury selection with Lori Vallow, Daybell Esquire. So there's that. I'm hoping that they're on schedule and that her trial will start with opening statements June 3rd. I'm keeping an eye on it. Don't you guys worry. Hey, Sprinkled Donut, good morning. I'm keeping an eye on it. So when it begins, and I will stream it semi-live here. We'll be behind a little bit, but given how there's that delay and oh, did he? Okay, thank you, Melissa. I'll go check it out. Thank you so much, babe. I appreciate it. Shout out to Nate Eaton at East Idaho News, as if he actually needs a shout out from the ward. But I do. I adore Nate. He's so thorough. He's so professional, and quite frankly, he has a lot of patience for Lori's shenanigans, and he does a really good job at professionally explaining it, where I tend to lose my patience and just read her for absolute filth. Maybe what I'm going to start doing this time around is I'm going to work on doing a church read. So this way I can read Lori for absolute filth, but it's not all yelly and cussy, and like it's professional. So that's my plan. Anyway, we'll see how it goes, because sometimes some of the stuff that comes out of Lori's mouth and the way that she is disrespectful to the court, it's very difficult for me to maintain composure. Hey, Birdie, good morning. Happy Friday. Good to see you. So yeah, now we wait. They're at a sidebar. What else was I going to tell you guys? I totally forgot. There was something else I had to tell you guys, but alas, it's gone out of my brain. Probably never to return again. We'll see. Sometimes it comes back to me. Sometimes it does not. Hey, Trio Good Mom. Good to see you. Good morning. Happy Friday. Right, Tess? And I'll tell you guys, Tess says that Lori asked the same damn questions 56 ways, expecting a new answer she likes better. And there is at one point, okay, when Judge Bresky said you're right. And I'm telling you guys, even though we couldn't see her face, I could hear that little hamster on the wheel. That's all she heard. And after the last syllable, the last little on right was out of Judge Boreski's mouth, completely tuned out. She was done from that moment on. and you could tell, you know, all that was going on inside that brain of hers was that wind up toy, that monkey with the cymbals that claps. That's it. Yeah, she's a mess. But it's all coming to an end. Good morning, Mrs. Troy. Good to see you. We should count the side boss. Me too, Tess. I just love Nate so much. I do. I really do. I'm going to tell you guys, hey, it's about time. Good morning. Good to see you, hobo. This is when I began my love for Nate Eaton in a completely platonic way, Mrs. Eaton. Don't you worry. When Lori and Chad were in Hawaii and Nate marched up to her and he said, "Where's your children, Lori? Where are the kids, Lori? Everybody wants to know where the kids are, Lori." Right then, because that is what everybody wanted to know. And you could tell that it got under her skin. And she has been carrying that grudge against Nate until this day. The end. That's it. That's all. And she is just as salty on May 30th, 2025, as she was back in 2020 when he asked her that. It might have even been 2020. No, it was 2020. Yeah, she is, I think she dislikes Nate at a cellular level at this point. Like it's part of her DNA. If they were to take Lori Vallow Daybell's DNA and analyze the strands, okay, there's a new strand on her DNA that carries the "I loathe Nate Eaton." Okay, and you know what? Too bad, so sad, Lori. Nate is a great human being. You, however,
We'll start with the required finding argument.
oh, here we go.
So I'll hear you whenever you're ready, Mr. Jackson.
Thank you, Your Honor.
Sure.
Thank you, Your Honor. We filed this morning a motion for required finding of not guilty under Massachusetts Rule of Criminal Procedure.
I was wondering when this was going to happen. Okay. Usually this happens immediately following the state's resting. Okay. I think the reason they didn't do it yesterday, as you know, is because it was supposed to be a half day and, all the things. And that when it's a half day, the minute she sits down at the bench in the morning, that's all she can think of. It's a half day. So this is normal procedure. Let's keep going.
Procedure 25A. I think that's before the court. My comments will be relatively brief, but it's important, and the points that I'm going to make in the next couple of seconds or next couple of minutes are equally important. It comes down to the following. The Commonwealth has simply not proven, even in a light most favorable to them, that there was a collision on January 29th, 2022 at 34 Fairview in Canton, Massachusetts. There was no collision proven to have occurred. There was no eyewitness presented. There was no video evidence, no audio evidence, no evidence in the form of physical evidence at the scene by searches that were done by officers on the morning of January 29th, 2022. The Commonwealth, through suspect experts based on circumstantial technical data, only sought to prove a backing event, and that's important. They sought to prove that at 34 Fairview, the SUV went backward. They did not prove, and every single one of their experts was asked this question, they did not prove that there was actually a collision associated with that backing event. The Commonwealth experts said at best that the car went in reverse, and it was suspect whether it went in reverse at 34 Fairview or some other place time, or date. The Commonwealth also put on an expert who said that she found no injuries, none, mind you, indicative of a vehicle strike on John O'Keefe's body. And she, Dr. Irini Scordi-Bello, was arguably their most important witness. The Commonwealth cannot and did not say or prove a collision at a particular time, a collision at a particular place, a collision with a particular person, or that a collision even occurred on January 29th, 2022 at or around or at or after 12:30 in the morning. Their own expert, I think it was yesterday, if not the day before yesterday, was asked on examination by Mr. Alessi, can you tell us the particulars of the collision, pardon me, as you suggested in your testimony? And his answer was, there's simply not enough evidence. He was asked specifically, why didn't you try to recreate the circumstances, the force impact? That's what you do, sir. You're a biomechanic expert. Recreate it for us. And he said, there's not enough evidence. There is evidence, however, that Brian Higgins and Brian Albert were sparring at 34 Fairview. There is evidence, however, that that was just minutes, not hours, not days, minutes before John O'Keefe ultimately met his fate at 34 Fairview. There is evidence that Brian Higgins was love-struck, that he was jealous, that he was aggressively coaxing John O'Keefe out of the waterfall, that he was passively aggressively coaxing Miss Reed to engage with him rather than John O'Keefe. Again, there was not a single eyewitness to a collision. There was not even a single eyewitness to a backing event at 34 Fairview. The court will recall Jennifer McCabe testified that she basically watched the SUV the entirety of the time it was in front of the location at 34 Fairview with Miss Reed in the driver's seat. She saw it pull up once. She saw it pull up twice. She saw it pull up a third time. And then she saw it was gone. And at no time did she ever see the car go in reverse. She certainly didn't see the SUV go in reverse at a high speed. And she darn sure didn't see the car go in reverse at a high speed and strike a pedestrian. Her focus was defined enough to see thin tire tracks in a dusting of snow, thin enough, I think the phrase was, to track a cat. That's how detailed she was in her observations, yet she did not see John O'Keefe hit by an SUV. She did not see John O'Keefe's body in the snow, in the yard, laying prostrate, a 216-pound, 6'1" man in the snow, directly in front of the SUV she was tracking the entire time. There are two other witnesses, Ryan Nagel, Heather Maxson. They both noted that John O'Keefe, not that they didn't see him, Your Honor, that John O'Keefe was not in the vehicle when they were behind it. The dome light was on. They could see inside the interior of the vehicle. Miss Reed was sitting there with her hands at 10 and 2, and the passenger seat, notably and markedly, was empty. He was not outside the vehicle. He wasn't standing. He wasn't sitting. He wasn't lying down. There's only one place he could be: inside the curtilage of the home, inside the house, or inside the garage. Not one witness that was inside the house, not one passerby, not one neighbor, not one plow driver ever saw John O'Keefe's body laying prostrate in the snow that morning. Not one. Not until Karen Reed found Mr. O'Keefe at about 6:03. And again, the Commonwealth's chief medical expert, Dr. Scordi-Bello, their medical examiner, who's the only person that the court heard from or will ever hear from who actually investigated John O'Keefe's physical body, the only person to have physical access to John O'Keefe, testified He did not have any injuries consistent with being struck by a vehicle. But she did indicate that the injuries, as did the firefighters, the first responders, indicate that he had injuries consistent with a physical altercation. And certainly, as to counts 1 and 3, no evidence has been presented or proffered whatsoever by the Commonwealth that Karen Reed intended to run over and harm John O'Keefe in any way, shape, form, or fashion. Hearken to the video at C.F. McCarthy's. Hearken to the video at the waterfall. Every witness confirmed what our eyes could see. That night, John O'Keefe, Karen Reed were loving, caring, affectionate. There's absolutely no evidence that Karen Reed had an intent to harm John O'Keefe, or that that after the fact, that she intended to leave him for dead, because there was no fact to be after. There was no collision in the first place. The Commonwealth's case, certainly on counts 1 and 3, taken separate from count 2 because of the Commonwealth, at the end of the day, has presented their best case. They've done their best. Some would say they've done their worst. And their case has failed. No reasonable jury, hearkening back to the standard under Rule 25, no reasonable jury could find Karen Reed guilty of count 1, count 2, or count 3. But taking count 1 and 3 aside, those are separate counts because of the mens rea required and the high burden that's required, even taken in the light most favorable to the Commonwealth. What evidence have they proven that Karen Reed intended to kill or harm John O'Keefe, or that she intended to leave him for dead in the snow? The answer is none, 0. No reasonable jury could find Karen Reed guilty. This case never should have been brought in the first place. There are reasons that I won't go into here. The court knows those reasons, or knows our position on those reasons. This was a vindictive prosecution, and I believe that the court is duty-bound pursuant to the precepts of Rule 25A, as well as the principles of justice, to dismiss all 3 counts. And certainly, taking count 1 and count 3 aside, the court is duty-bound to dismiss those 2 counts. Thank you.
In a light most favorable to the Commonwealth, the first issue the court should look to is intoxication. A reasonable fact finder would find that the defendant was in fact intoxicated. Based on the serum conversion and based on Karen Reed's statements herself, you've heard many, many admissions by the defendant about her level of intoxication, which far surpassed the statutory mandate that she consumed alcohol in a way that would affect her ability to operate safely. Those are just 2 of the cornerstone pieces of intoxication, which are clear, light most favorable to the Commonwealth, a reasonable fact finder could find beyond a reasonable doubt. The evidence of collision is abundant. I do not want to go through an entire closing argument or rhetoric, but suffice to say there are taillight fragments from the defendant's own Lexus, from her shattered right taillight, that are found in Mr. O'Keefe's clothes. Mr. O'Keefe is left at the very spot where she expects to find him, according to her statements, where her car does a backing maneuver at least 24 miles per hour. He is left with injuries on his arm consistent with the damage to her Lexus right rear taillight. The scientific data is substantial. Telestream data, Apple Healthcare data, battery temperature data. And again, Ms. Reed's statements herself about clipping, hitting. The evidence of a collision in this case is overwhelming. It is a public way. Lieutenant Gallagher told us about Fairview as being a public way. And so as to the operating under the influence of alcohol manslaughter, the conduct of driving in that forward and backing maneuver after being intoxicated meets clearly the standard for OUI manslaughter. Regarding second-degree murder, as highlighted in my opening statement, the defendant engaged in intentional conduct that was her maneuver of driving forward, stopping, and then driving back to Mr. O'Keefe on January 29, 2022. Under the conditions that night after being intoxicated, that conduct was intentional, and any reasonable person could find that her conduct that night created a plain and strong likelihood of death. There is no predicate of intending to kill or even intending to hit. There is clearly a plain and strong likelihood of death driving a 6,000-pound SUV forward and then back. In addition to state of mind, again, the defendant tells us herself. Through firefighter Becker, they're arguing, they're upset. We see the text messages, evidence of attempted breakup, and we hear the words of Karen Reed when she leaves numerous voicemails that night, and you can hear her voice. There are statements, I do not want to go through a summary of all of them, but statements from the defendant herself where she acknowledges an injury to Mr. O'Keefe. She's the last one with him, where to find him, and her hypothesis about hitting and clipping him. As to leaving the scene, again, the defendant tells us that when she leaves, he doesn't look mortally wounded. She leaves him, makes dozens and dozens of calls, but never goes back to help him and leaves him to die. And we heard from Dr. Wolf about the life-saving procedures that could have been initiated. The chance of survival was never given to John O'Keefe. All of those facts suffice under Lattimore, a light most favorable to the government, that a reasonable fact finder would find beyond a reasonable doubt, or could find beyond a reasonable doubt, each and every element of each and every one of these charges.
All right, thank you. So the motion is denied as to all three indictments.
Of course it
And
is.
the other topic that we were discussing at sidebar, I don't need to hear argument on that right now, Ms. Giannetti. I'd prefer to get started. I would like you and Mr. Brennan to talk to see about proposal.
Thank you.
So are we ready to bring the jury in? I did not ask you at sidebar. Are you ready for this witness, Mr. Brennan? Mr.
I'm ready.
Okay, so,
Thank you.
all right, so we'll bring the jury in. That will take 5 minutes, Paul? All right, so we'll take the recess.
All rise, please.
Well, I don't know how you guys are feeling this morning, but for me personally, I am shocked the Judge Bev didn't dismiss. I didn't rule in favor of this of the defense. Shocked. In fact, I'm so shocked. I really don't know how I'm going to recover from all of the shock. All right, so we've had people come in. And I want to say good morning to everyone that just came in. It's good to see you. Thank you so much, everyone, for being here. I appreciate it. I'm so over it. It's like Bev, look, you're not going to win any Oscars, okay? Nothing for protect. You try to come across as if you actually are listening and pondering the argument before you, and you haven't made a decision yet. It's not working. It's all over your face, and then it's in the tone of voice in which you make your ruling. Okay, that you already knew how you were going to rule. It is what it is. Although, to be fair, that I don't, It's usually called a motion for a directed verdict, okay? That's how I know it to be called, but I guess it's called something different in Massachusetts. Anyway, those are rare. Those are hardly ever successful. Like, I don't think I've ever watched a trial where the judge is like, you know what, you're right. They ain't proved shit. Okay, no, that never. I don't want to say never because obviously it's not a good idea to speak in absolutes, but I've never seen it happen. Is what I'm saying. I have yet to witness that occur. So yeah, it's not one of those things that I've ever seen be successful, but it's procedural and it is what it is. Although in this case, I mean, at the end of the day, they haven't proven it. I don't see how anybody how Judge Bev. I'm not talking about like a moral standard here, okay, or an ethical standard of proof. I'm talking about the legal standard. Now, while I do believe that um, um, Karen Reed is factually innocent, the defense, they don't really have to prove her not guilty. But at this point in the trial, okay, just taking what we've seen in the trial, that's it. That's all. Okay. I don't see how they've proven any of the elements. I don't see that. I mean, okay, maybe they might have proven that she potentially was driving while intoxicated. Okay. I mean, even if you take the most conservative count of her alcohol consumption, she shouldn't have been driving. The fact of the matter is, there were a lot of people driving that night that shouldn't have been driving, that had no business driving that night and should have known better, especially given their profession. And I'm going to leave it there. And she had exactly, Tess, she admits that though. And it's interesting to me that no, Lisa, we're all daying it today. Of all of the things, okay, that are clear admittals of guilt. No. Yes, that's the right word. The drinking is the one. They shouldn't have been driving because she was intoxicated. She readily, and that is the most clear admission of guilt in all of the 11 billion clips that Brennan could have played. He didn't even play that one, which is ridiculous. All the other clips that he played that he is holding out as some sort of evidence of consciousness of guilt aren't even consciousness of guilt statements. Like, I don't see, I I can't even. And that's the one thing they have her on that she admits to. Everything else is like redonk. And the thing is it's such a reach for the Commonwealth to be like, well, we got that part of the evening right. So, we must have got the rest of the theory of the crime or the theory correct too that night. No, no, that's not how it works. And that is such a super reach. Listen, Brennan, sir, I really hope that you're stretching before you're doing all them reaches because you're going to pull something for real. Exactly, crocheting Bammy. Like, there were a lot of people on the road that night that shouldn't have been, number one. And number two, really should have known better given their profession and its conduct unbecoming for sure. I believe, let me see. Hold on. Let me see what Karen Reed is facing. Okay. It says, if found guilty, Karen Reed could face life in prison for the most serious charge of second-degree murder. She also faces charges of manslaughter and leaving the scene. The maximum, it doesn't say what,
You are unmuted.
I'll have to look more up to more. I'll have to look more in depth on that. Let me see what let me see what the manslaughter is.
Hear ye, hear ye, hear ye. All persons have any business before the Honorable Beverly Cannoli, Justice of the Norfolk Superior Court, and for the country of Norfolk. Draw near, give your attendance, and you shall be heard.
20 years, up to 20 years in for manslaughter.
Good morning again, counsel. Good morning again, Ms. Reed. Good morning, jurors. Happy Friday. So I do have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? No. As you know, yesterday the Commonwealth rested, and as you know, the defendant has absolutely no burden of proof in this case, does not have to put on a case, but I hear that you are. So your first witness.
I hear that you are. Are you okay? First of all, Bev, let's just start here. It's friggin' 9 o'clock in the morning, and you are having to hold on to the bench to steady yourself. Okay, come on, Judge Bev, get it together. I hear they're going to make as if you didn't sit through all the pretrials. Shut up. All right, let's start. Here we are. This is what we've been waiting for. Come on, Mr. Jackson.
Okay.
Oh, Chess was right. Oh, Kelly, thank you for being a member for 4 months. I appreciate that, babe. Thank you for supporting me and the channel. Come on, Matthew, get on up here.
So you're gonna step up, face the front, and raise your right hand.
You solemnly swear the evidence you give the court and jury in the case down here is for the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Thank you.
I knew you would be, Tess. But you never know. Up until the moment they're called, you know, they can throw a curveball in there.
All right, Mr. Jackson, whenever you're ready.
Thank you. Mr. DeSogra, could you please state your full name and spell your last name for the jurors, please?
Sure. Matthew DeSogra, last name D-I-S-O-G-R-A.
What do you do for a living, sir?
I am a licensed professional engineer. I practice in the field of accident reconstruction, and within that field, I specialize in analysis, interpretation, and accessing all types of vehicle data.
How are you currently employed?
I'm employed by Delta V Forensic Engineering, which is an engineering firm that specializes in accident reconstruction, all parts of accident reconstruction.
Tell us a little bit more about Delta V. What is it? What kind of company is it? But other than that specialty, what else does it do?
So accident reconstruction is a broad field. There are a lot of subspecialties within that. So accident reconstruction is everything from the initial investigation phases of a crash all the way through testimony, like here today. Some of the specialties within that could be things like biomechanics, could be human factors, And my specialty is data, vehicle data, and event data recorders.
Staying on that topic, what is your current title or position with Delta V?
I am the Director of Engineering for our EDR services line.
What does EDR services mean?
So, event data recorders. So EDR is a general term we can use to talk about all types of data from all types of vehicles.
And how would you describe your role as the Director of Engineering for EDR services for Delta V?
I wear a couple of different hats. First and foremost, I'm still a practicing engineer. I still conduct investigations. I still perform analyses, and I testify. On top of that, in the director role, I oversee a group. It's not just me doing this kind of work. I have 3 other engineers that work with me, all specializing in EDRs. So I oversee that group and focus on kind of the day-to-day operations as well as the direction we're going. You know, with things like autonomous vehicles coming, the role of data is growing, so we're kind of looking to the future in a lot of those ways.
As a consulting engineer, you've indicated what your specialization is. Do you specialize in motor vehicle accident reconstruction as well as vehicle system analyses?
I began my career at Delta V doing traditional accident reconstruction in the broadest sense, and as I have progressed, I have sort of narrowed myself down and now specialize in that. But I still consider myself an expert in accident reconstruction because ultimately,
No, please finish.
Ultimately, anytime we're doing EDR or data analysis, it is in support of an accident reconstruction.
You talked about event data recorders. Do you also engage in the specialty of advanced data recovery methods? In other words, methods of pulling the data. It's one thing to have it sitting in a car. It's another thing to pull it out and make it useful, correct?
That's right. There are a lot of different ways data can be accessed, all the way from just plugging into a port on a working vehicle, all the way through when a vehicle is catastrophically damaged and even the modules themselves are damaged, accessing the data at the chip level. So no matter what condition a vehicle or the remnants of a vehicle are in, generally we can still get the data from that.
Do you have any specific knowledge about Toyota data?
I do.
Describe that for us.
Beyond Toyota being a common vehicle in general, so we run into that data quite frequently. Just this year, we published a paper specifically studying some of the behaviors of the additional data recorder that's in Toyota vehicles.
Does Toyota make another sub-brand, for lack of a better phrase?
Lexus, I believe you're. Mm-hmm.
So Lexus is a Toyota brand, right?
Correct.
Okay. What is infotainment? It's kind of a combination of a couple of words, information and entertainment. What is infotainment data as it relates to vehicles, modern vehicles?
So it's a generic term, which more or less means the thing that's in the middle of the dashboard with the screen on it. A lot of manufacturers implement that a little bit differently, so they all look different, but it's a general term we use in the industry to describe that system.
And what about, I'm going to change gears a little bit, what about your experience with regard to GPS as it relates to vehicles on the road, on the common roadways of the country?
GPS is a pretty fundamental part of vehicle data as a whole at this point, and we run into it in a lot of different places. We see GPS data from infotainment systems, so we're analyzing that data. Most of that's GPS-based. I do a lot of heavy truck work, and almost every heavy truck has some kind of GPS system in it for the fleets to track them, so we're analyzing that as part of data. And then the last area would be when we conduct testing, any kind of research, we're generally going to put our own GPS systems on vehicles so we can study that data. So analyzing GPS is a regular part of my job.
GPS, global, I'm going by memory, global positioning satellites?
Global positioning system.
System, got it. GPS is a mechanism to figure out where on Earth a certain item might be, whether it's this pin or an 18-wheel tractor trailer, correct?
That's correct.
Is there any difference inherently in the GPS mechanism that's installed in an infotainment center in a Toyota Lexus, versus a heavy truck or a heavy vehicle that's on the road?
The core technology behind how it works is fundamentally the same.
What is instrumented testing as it relates to Toyotas and VCH testing and things of that nature? Can you explain that for the jurors?
Sure. what instrumented testing means is, let's say we want to study, let's say, how accurate some data is that comes out of one of these vehicles. So we need an independent source of that information. So what we'll do is we'll equip a vehicle with one of these GPS data acquisition systems. Basically, we can drive the vehicle around and we know exactly where it is, how fast it's going, all these parameters. We can do some maneuvers with the vehicle, then we can download the data that the vehicle stored, and now we can compare the two and say, okay, well, if we have really high confidence in our system, how accurate is the vehicle system? Because the reality is there's always some small errors in these vehicle systems. And in a lot of cases, what's important is quantifying that error.
So you're obviously familiar with GPS systems in many different platforms.
That's correct.
Okay. How many cases have you been a part of in terms of investigating and or analyzing infotainment center or infotainment system data?
Infotainment specifically, probably around 30.
And are you also familiar with engaging in some sort of analysis that's referred to as clock alignment?
Yes.
What is clock alignment?
Clock alignment would mean that anytime we have a timestamp in any set of data, a singular clock value, there's a good likelihood that that's not 100% accurate. So clock alignment would mean finding an independent source of time to compare that to, preferably one that's more reliable, and then making the necessary adjustments so that time can be considered real time.
How many cases have you been involved in that deal with clock alignment specifically?
Thousands, over 1,000. That's a regular part of data analysis. Any data set that has a timestamp, it's normal. It's part of the analysis. It's really the first step is let's get that clock aligned. So it's something I'm doing regularly.
And how long have you worked for Delta V?
It'll be my 13-year anniversary next month, actually.
Okay. These things that you just described that we've talked about for the last few minutes, these are all duties that you perform within the rubric of your employment as the director of engineering at Delta V, correct?
Correct.
Now let's shift gears real quick and talk about your education, training, and background that qualifies you to perform these duties that you just talked about. Go ahead. The road is open and it's yours.
Certainly. So I began my academic career. I got an undergraduate degree in mechanical engineering from the University of North Carolina at Charlotte. I then went on and got a master's degree also in mechanical engineering from the same school. And then when I came out of school, I immediately started working for Delta V, Forensic Engineering. In order to get a professional engineer license, I then needed to acquire 4 additional years of work directly under the supervision of another licensed engineer. So then I completed that phase of work. And then in order to maintain my license, I have to complete continuing education every year in the field that I practice.
So you got both a Bachelor of Science, correct?
Correct, Bachelor of Science.
Did you mention the year that you got your Bachelor of Science?
2011.
And you have a Master's?
Correct.
In engineering?
That is correct.
And when did you secure that degree?
2013.
You just mentioned engaging in continuing education. What is continuing education in terms of the engineering field or the reconstruction field in your world?
So in the state that I'm licensed, in North Carolina, they define that really as any activity you're participating in that's keeping you abreast with the field, keeping you up to date with what's going on. So taking formal classes counts for continuing education, but also some of the other work that I do, like publishing research in peer-reviewed journals, also counts as continuing education. Do you
regularly attend symposiums or symposia, I guess is the right
Yes.
word? Have you attended symposia related to EDR research and training?
Yes.
How about advanced applications of heavy vehicle EDR data?
Correct. Yeah, I attend. There's a couple of regular conferences in our industry specifically tailored to EDRs as a whole for passenger vehicles and heavy trucks. I'm a regular attendee of those. I'm also a regular speaker at most of those. And I'm usually presenting some of the new research that we have for that year.
So not only do you attend, you actually teach?
Correct.
Have you attended Have you attended events that deal with data, event data recording systems, and event data recording system extraction?
Yes.
What about vehicle crash reconstruction?
Yes.
What about electronic control module imaging?
Yes.
What about electronic control model analysis?
Yes.
Applying automotive EDR data to traffic reconstruction?
Yes.
These are samples of the type of continuing education that you routinely engage in, correct?
All that's accurate.
You talked about additional licenses and professional registrations. You're a licensed professional engineer, correct?
That's correct.
In North Carolina?
Correct.
You're also a certified IPC specialist?
Yes.
What is an IPC specialist?
IPC is an organization that offers certifications in basically soldering. I could say it in more technical ways, but it boils down to soldering. So as it relates to what I do, when we are recovering data from damaged EDRs at the chip level, that involves some really precise soldering work. And so IPC offers courses in how to do that at basically the highest level, and then they offer certifications for that.
Are you a member of the Society of Automotive Engineers?
I am, active member.
When you say an active member, is that a nationally recognized society for academic engineers?
Yes.
The teaching roles that you've held within organizations, have you been an instructor concerning accessing and interpreting heavy vehicle data event recorders?
I am. I'm currently an instructor of that course, which is offered through the Society of Automotive Engineers.
As a matter of fact, next week, are you going someplace to teach?
I am. I will be in Wisconsin next week teaching that very course.
Are you a member of any subcommittees within that organization, within the organization of the Society for Automotive Engineers?
I am. I am a voting member in the J2728 subcommittee, which is a subcommittee for event data recorders on trucks and buses.
Are you also a member of the National Association of Professional Reconstruction Specialists?
I am.
Does that require a certain level of education?
It does, and it requires, as far as I know when I joined, sort of proof that you are active within the field of accident reconstruction.
That was my next question. It requires you to stay current on accident reconstruction issues, correct?
Correct.
Have you also authored peer-reviewed articles on within your field and
Yes.
subfield? Is it fair to say that you've authored or co-authored a number of peer-reviewed papers in the field of accident reconstruction specifically, as well as EDR data retrieval?
That's correct.
Have any of your peer-reviewed articles that you've either authored or co-authored specifically focused on Toyota vehicles?
Yes.
Can you name one, please?
Specifically, this year published a paper where we studied the effects of collision-induced power loss on the way data is recorded in Toyota systems. And that would include Lexus systems. Fundamentally, they're the same components. It's just a different brand on top.
In January 2025, did you co-author a publication entitled Simulation of Vehicle Speed Sensor Data for Use in Heavy Vehicle Event Data Recording Testing?
Mr. Jackson, you're going to have to repeat that.
Of course. Sorry. In January 2025, did you co-author a publication entitled Simulation of Vehicle Speed Sensor Data for Use in Heavy Vehicle Event Data Recorder Testing?
Yes, I was the lead author on that paper.
When you're dealing with retrieving data from a vehicle, an EDR, an event data recorder, Toyota paper, whatever it might be, and that's a term of art, Toyota paper, correct?
Sure.
Does it matter if the vehicle is a heavy vehicle, a small vehicle, a passenger vehicle, a moped, or a skateboard if they happen to have an infotainment center on it?
There are differences, of course, between the data that comes out of passenger vehicles and the data that comes out of heavy trucks, but there are also a lot of fundamental similarities to those. Like, for example, they all record vehicle speed. They all have accelerator pedals. They all have brake pedals. So a lot of the core data we're analyzing is very similar.
In January 2020, did you co-author a publication entitled Chip and Board Level Digital Forensics of Cummins Heavy Vehicle Data Event Recorders?
Yes, I did.
Okay. And what was the fundamental, without getting into the granular details, the fundamental aspect of that paper?
So, in that research, we introduced a new technique for getting data out of damaged modules. So, you know, they're either burned, they've been submerged in the water, they're crushed physically from impact. We demonstrated a new method to be able to get data less invasively, but still at the chip level. And we also demonstrated that we could translate that data from the chips outside of the software that was provided. So you could use the software and get the data that way. We demonstrated we could basically do it ourselves if we wanted to.
Mr. DeSogra, have you been qualified in other courts to testify as an expert in the area of accident reconstruction, EDR, data retrieval and recovery?
Yes.
How many times?
Once.
When was that?
In New York.
You were deemed qualified as an expert in that court in this field that you're talking about today?
Specifically with, as it relates to data, yes.
I want to talk a little bit about what you were asked to do in this case. We asked to undertake a review of certain work performed by a person by the name of Shannon Burgess with Aperture LLC.
Yes.
Are you familiar with Aperture?
Yes.
Before you were asked to undertake that review, were you familiar with Aperture?
Yes.
Were you familiar specifically with Shannon Burgess?
Yes.
Were you asked to engage in any original analysis in this case?
All of my analysis is fundamentally based on all of the data and the numbers provided in the Aperture reports. So more or less the answer to your question is no.
So you were asked specifically to give the court and the jurors clarity on data that Shannon Burgess had analyzed and provided a report about, correct?
Correct.
And that dealt with data obtained from Ms. Reed's SUV, Karen Reed's SUV, correct?
Correct.
Did you, in fact, review Shannon Burgess's report summarizing his findings and conclusions regarding clock drift? That report was dated in January of 2025.
Yes.
And what did you do in that regard?
I analyzed the methods that Mr. Burgess proposed for aligning the clocks in that report.
Were you also asked at some point to review Judson Welcher's report and PowerPoint presentation regarding the timing of the text stream event known as 1162-2, 1162-2?
Yes.
Did you determine whether Dr. Welcher had based his report on Shannon Burgess's analysis?
Yes.
Before we get into that, I want to ask you a couple of questions about text stream events, so we're all talking sort of with the same vocabulary if we could. When I say text stream event, have you ever heard that called a trigger event?
Yes.
Are those sort of synonymous?
The event, in order to be generated, has to be triggered by something. So, yes.
You became aware in your analysis, I'm assuming, that Dr. Welcher reported a trigger event at a particular time or span of time, correct?
Correct.
What span of time was that? I should say, what time was that?
For which event?
For the 1162-2 event, sorry.
Do you mind if I reference the slide? Because I don't have the number committed.
With the court's
to
permission.
Go ahead.
Do you have a copy of it in front of you?
I do, Your Honor. So the original analysis places event 1162-2 ending at 12:31:43 a.m.
Now, Dr. Welcher, and this is what I want to talk about for just a quick second. Dr. Welcher indicated that the trigger event began at 12:31:38, correct?
I believe so.
That would suggest that a trigger event lasts 5 seconds, 12:31:38 to 12:31:43, correct?
Objection.
Sustained is to form.
Let me ask you this. Does a trigger event or does a text stream event last 5 seconds or 10 seconds?
The trigger is a singular point in time.
That's my question. All right, so if we're thinking about a trigger event, it's like that clap, snap, right? It's a point in time, not a series of, not a time span, correct?
It's a singular point, correct?
Okay. Does a trigger event or a text stream event cause a recording to bookend the trigger event itself.
Yes.
Explain that for the jurors so that we're very clear about that.
Sure. So when an event is triggered, what we end up with is some data from before the event was triggered and some data from after the event was triggered. The way it does that is it's kind of always recording, and as soon as it sees a trigger, it says, aha, and it goes and it grabs the previous 5 seconds. That number can vary. It can be more or less than 5, but for the specific trigger we're talking about, it grabs the previous 5 seconds of data, and then it keeps recording for an additional 5 seconds, and that completes its recording phase.
Right. So if Dr. Welcher indicated that the text stream event, the trigger, was at 12:31:38, would it be accurate if he said that trigger ended at 12:31:43?
Objection.
Sustained as to form.
Is there any, if a trigger event is one point in time, one snap in time, would it be accurate to say that the trigger event itself lasted 5 seconds and ended 5 seconds later?
It wouldn't be accurate to say the trigger lasted that long.
That's my question.
The event lasts that long, but the trigger is only one point within the event.
The recording lasts that long.
Right.
Correct?
Correct.
So in other words, it captures, or does it, let me ask you this, does it capture 5 seconds before and 5 seconds after? But the trigger event is the singular point right in the middle.
That's correct.
Okay. If we were to calculate the window between the trigger event or the text stream event and a lock event on John O'Keefe's phone, you analyzed both, correct? Or you reviewed both, correct?
Correct.
Would you calculate from the point of the trigger, would you calculate from 12:31:38, that point in time, and I'm using the tip of my pen to represent the point, at 12:31:38, or would you calculate it from 12:31:43?
Customarily, when we're doing any analysis, we're referencing everything off of the trigger. That's the normal way. Everything in the aperture reports was referenced off of the end of the event. So
Of the recording event.
Of the recording event.
Not the trigger.
Correct. And I didn't correct that. I just went with that convention for all of the analysis I did.
But you noted it, correct?
Correct.
And you noted that that would be 5 seconds inaccurate? I'll withdraw it. I'll ask it a different way. What would be the effect of timing if you were to start at the trigger event, 12:31:38, versus timing the event if you were to start at 12:31:43?
There'd be approximately 5-second difference in every subsequent calculation.
And if, in fact, there was a lock event, which you reviewed, at 12:32:09, how long would the actual window be from the trigger event to 12:32:09?
It would be larger by 5 seconds, approximately.
So it would actually be 31 seconds, correct? Did I do my math right?
You did.
Let's get back, if we can, to the offsets that you identified in Shannon Burgess's, the time offsets that you identified in Shannon Burgess's report. When you applied the potential offsets identified by Mr. Burgess to the text stream event at 1162-2, what opinions or conclusions did you come to with regard to that analysis or that question?
Objection.
Sustained, ask it differently.
Did you apply the potential offsets identified by Mr. Burgess in his January 2025 report to the text stream event 1162-2?
Yes.
did you also apply Dr. Welcher's analysis based on that same Shannon Burgess analysis to reach an opinion or a conclusion?
Yes.
And what was your opinion or conclusion with regard to that event and the timing following that event?
Based on all of the data in those two original reports, regardless of what adjustment is made or which 2 points are used to try to correct the clock, the phone lock event always occurs after the end of the event, using their convention of referencing off the end of the event, not the trigger, but it always occurs after.
And that was based on Shannon Burgess's January 2025 report, correct?
Correct.
Sustained.
What was that based on? Which report? We're dealing with two different reports, May and January. I want to make sure we differentiate. Which report are you just now talking about?
I'm talking about the January report.
Now, did Mr. Burgess, were you supplied with a supplemental report by Mr. Burgess?
Yes, I was.
When was that?
Slightly after he issued it, but I don't know the exact date.
Say that again?
It was issued on, his report was dated May 8th, and I think I was provided it a couple days after that. I don't
Okay.
remember the exact date.
So after, well, do you know when this trial started?
No, I don't know the exact date.
I know you're not watching the trial, but it was in the middle of this trial, correct?
Sustained.
I'll ask a different question. With regard to the original report, the January 2025 report, was there any circumstance in which Mr. Burgess and Mr. Welcher could conclude that the lock event on John O'Keefe's phone, that lock event, occurred before the trigger event?
Objection.
Sustained. Ask it differently, Mr. Jackson.
What is your opinion about whether or not there was any analysis done by Mr. Burgess or Mr. Welcher that put the lock event occurring before the trigger?
Objection.
Sustained.
May we approach, Your Honor?
Yes.
Brennan, I'm going to need you to stop objecting. I know you don't want this to come in. I know you don't want the jurors to hear this, but they need to hear it. If you're so confident in your case and you're so confident in your experts and their testimony and their analysis, then let it come in and let the jury decide which one is accurate, which one is not. Like, come on, Brennan, this is ridiculous. So ridiculous. So ridiculous. Medusa, I need to. I'll wait, though. I'll probably just end it 2 so that I can be ready to go at 3. That's probably what I'll do. That's the more professional thing to do. And so that's what I shall do.
May I, Your Honor?
Yes.
Thank you. Back to my question. Was there any circumstance, based on your review, that if the text stream event occurred at 12:31:38,
Hey,
that
Destination.
there was any
Good to see you,
circumstance
babe.
that the lock event occurred before that trigger event?
There was not.
Hold on. I want to answer 7 Lilies. Good morning to you, by the way. I missed you coming in. So 7 Lily says, why does he not have to say on what grounds he's objecting? Don't they usually have to say objection, hearsay, or whatever? Usually so it depends on the judge. Judge Bev doesn't like speaking objections. So that's why we don't hear that. Oh,
Did you create
okay,
a
Tess. Thanks, babe.
PowerPoint for clarity's sake in March of 2025?
Yes,
Did you provide that to us?
I did.
What was the purpose of creating the PowerPoint?
The purpose of the PowerPoint was really to take a bunch of different data elements that were kind of placed throughout Mr. Burgess's report and Dr. Welcher's report in PowerPoint and compile them into a single source, a single table, essentially, to show as clearly as possible what the conclusions would be if we look at the data as a whole.
When you created that PowerPoint presentation, did you create it with the intention of providing it to the defense, which would then be provided to the Commonwealth?
Yes.
Are you aware of whether or not that was disclosed to the Commonwealth as part of the normal discovery process?
No.
So the answer is no, the answer is no.
Following your presentation of the PowerPoint to us, at some point did you receive from Mr. Burgess an amended report, an amended PowerPoint?
I received an amended PowerPoint by Mr. Burgess, not from him, though, from you.
Fair enough, fair enough. Did that report, or did that PowerPoint, however you want to put it, markedly, was it any different than his January 2025 report?
Yes.
Did you note any conclusions? Did you note the conclusions that he came to in January 2025? Going back to the original report?
Yes.
Did you note conclusions and opinions that he came to in May of 2025?
Yes.
Were those two things different?
Sustained.
Were the conclusions, not his opinions, were his conclusions different?
Sustained.
Was there any difference in the two reports?
There was.
Tell me the differences.
In the first report, Mr. Burgess did some of the calculations that are necessary to correct or adjust the times based on certain approaches, but never went through the final step of applying those calculations to the times and coming up with a final time. In the supplemental report, he then essentially took that analysis to the end. He approached it in a new way, a different way than he had previously laid out in the first report, but then he also took it all the way to the end by applying those calculations to the times.
What were the main differences? Explain for the court and for the jurors, what were the main differences that he changed in the May 2025 report?
Contrasting it with the original report. In the original report, he laid out some methodologies for correcting the clock using phone calls that were shared between the vehicle and Mr. O'Keefe's phone. And in the supplemental report, he moved away from the phone call analysis and moved to attempting to align the clocks using a shared maneuver between the vehicle and the phone.
What was the shared maneuver?
It was a 3-point turn.
Was that the same analysis that he had in January 2025?
He did not have that analysis in the January 2025 report.
Thank you. Based on the new information in the May 2025 report, what was the effect, as you see it, regarding the possible scenarios?
So I did the exact same process I did using the supplemental report as I did on the first report. And when I ran all those numbers and those calculations, it turned out there are now some scenarios in which the phone lock occurs after the end of the event. There's some scenarios where the phone lock occurs simultaneously, like literally at the same second. And there are some scenarios where it occurs before. So now there's a range.
So Mr. Burgess's report, his new report, his amended report, widened that gap to allow him to opine that there were scenarios that occurred after the phone lock event, correct?
Objection.
The objection is sustained.
Did you prepare a PowerPoint presentation in furtherance of clarifying Mr. Burgess's analysis?
Objection.
Sustained.
Did you seek to clarify Mr. Burgess's analysis?
Objection.
Sustained.
Your Honor, may we approach?
Yes.
May I?
Yes.
Did you prepare a PowerPoint presentation in furtherance of your analysis?
Yes.
What was the reason and what was the purpose for your PowerPoint presentation?
I needed to include in my analysis the approach and the conclusions from the supplemental report by Mr. Burgess.
May I have a moment, Your Honor?
Yes.
May I approach?
Yes.
If you wouldn't mind taking a look at that document, it's a multi-page document I just handed you, and just flip through it and let me know once you've familiarized yourself with it. What is that document?
This is a printout of the PowerPoint presentation that I prepared.
Is it true and accurate?
Yes,
And it's complete?
it appears to be.
Your Honor, I would move for its admission, please.
I have no objection.
Okay.
May I have that back from you for just a quick second?
208.
Thank you.
Your Honor, permission to display the PowerPoint presentation?
Okay.
Mr. DeSobra, can you still see with the lights off sufficient to see what's on the screen and what's in front of you?
Yes.
Okay. Do you recognize what's on the screen?
Yes.
What is that?
That is the title page of the PowerPoint that I prepared.
And what is the how would you describe the PowerPoint?
So this PowerPoint is largely identical to the first PowerPoint I prepared in that it seeks to take all of the different approaches between the initial Burgess report, the supplemental Burgess report, and Dr. Welcher's report, lay out all of those approaches in one kind of coherent fashion so we can look at what conclusions we can draw from all of that data.
With the court's permission, can we go to slide 2?
Yes. Mr. Jackson, you can just use this PowerPoint. It's in evidence. You don't have to ask slide to slide.
Thank you, Your Honor. Taking a look at this next slide, What is this? What are we looking at?
This is a slide from Dr. Welcher's presentation that I was provided. Specifically, this is his slide number 33.
And what does it show?
This is where he introduces the first, I guess, acknowledgement that there's a difference between the time that Aperture calculated for the end of event 1162-2 and the lock event on Mr. O'Keefe's cell phone.
Is there anything in this slide that you disagree with, in Mr. Welcher's presentation that you disagree with? It's up on the...
I added the 2 green boxes and the text, the word after. That's not Dr. Welcher's. And I added that because it's stated here that the event occurred within 26 seconds. But if we do the math, and he actually does the math, he really means after. It means the phone lock event occurred 26 seconds after the end of the vehicle event as calculated.
No, I'm going to allow it.
The phone interaction happens how many seconds after the text stream event?
Based on this slide, 26 seconds.
Thank you. And the text stream event that we're talking about is what number?
1162-2.
And this slide, other than the green, is this slide or the portion of the slide that we're looking at, other than what you've described, is this directly from Mr. Welcher's own analysis or his PowerPoint?
Right. I added the green box around within, the dashed green box around the whole paragraph, the line, and the words after. Those are my additions.
Let's go to the next slide. Can you tell us what this is?
This is more or less a repeat of what's on the first slide, but just shown with a little more focus. The first slide is a little busy. So what
I'm sorry, Mr. DeSogra, did you create this, or is this from Dr. Welcher's report?
I created everything on this slide apart from in the top right. That came from Dr. Welcher's slide 33.
Although you created the slide, where's the data coming from for this slide?
All of the data on this slide and all of my subsequent slides comes from the Aperture reports collectively, either Dr. Welcher's report or slides or Mr. Burgess's first and second reports.
What did their analysis reveal in terms of the exact time of the lock event for Mr. O'Keefe's phone?
So in their analysis, in Aperture's analysis, they report the Lexus event 1162-2 ends at 12:31:43, and they also report there's a phone lock at 12:32:09. So if we just simply take the difference in those two times, we get 26 seconds.
If you were to add the 5 seconds back to 12:31:38, which is the actual trigger event, what would you come up with?
31 seconds.
Which of the two, in your expert opinion, which of those two numbers is more accurate as it relates to the trigger event?
If we wanted to conduct the analysis relative to the trigger, it would be better to use the actual trigger time. However, as long as we're consistent through the analysis, it's not entirely wrong to use the end. It would be wrong if I suddenly switched up and started talking about this relative to the trigger event, but they present it as the end of the event, so I conduct the rest of my analysis using that convention.
Is another word for the end of the event the end of the recording?
End of the recording, yeah. When I say event, what I mean by that is the data event, the data recording event.
But the trigger event itself, 12:31:38.
Correct.
Okay. Did you put a name on this gap, if you will, this time frame?
Yes, I did. For the sake of the rest of the analysis that I'm going to do, I thought it would be helpful to just refer to this difference in time as John's interaction window.
And that refers directly to the interaction with the phone, the human interaction of locking the phone.
The 12:32:09 lock.
Okay. Let's go to the next slide, please. What does this slide show us?
So this, here what I'm doing is I'm kind of laying out the bounds of what I mean in John's interaction window, which should make, we have a lot of numbers to go through here, and so this should give us a very easy metric for kind of determining whether we have an event before or after. So what I mean by that is when we calculate John's interaction window, if that number comes out and is positive, that means the phone interaction occurs after the end of the vehicle event. And if we calculate John's interaction window and that number becomes a negative value, then that means the phone interaction occurs before. So now we have just a convention we can use really quickly to say, is it positive or is it negative? And we can maybe spare ourselves some of the math with 1,000 numbers.
So positive means what? One more time.
Positive, John's interaction window positive means the phone lock occurs after the end of vehicle event 1162-2.
Got it. Let's go to the next slide, please. What does this slide show us?
So what I'm saying here, I'm kind of laying the foundation for why we're going to even do this. Why do we need to start doing math on these clocks? So fundamentally, the phone, Mr. O'Keefe's phone, and the vehicle, Ms. Reed's vehicle, they're separate clocks. And it's very unlikely that they're going to be aligned perfectly in time. Right? If I compared my watch to your watch, it would probably be off. And that's the same case for any two independent clock sources. So Aperture, in their collective reports, propose a number of different ways in which that can be corrected. So I'm going to go through all of those ways that Aperture has proposed and show if we align the clocks based on how they laid out, does John's interaction window stay positive or does it ever become negative? Where does it end up when we run all those analyses? Or another way to put it is, does the phone interaction always occur after the end of the vehicle event?
And what did you determine?
Based on the initial reports,
yes,
the phone interaction always occurs after the end of the vehicle event.
Did all of the information that's on this slide come from the same source or multiple sources, meaning Mr. Burgess and Dr. Welcher?
In the PowerPoint as a whole, all of the information comes from the Aperture reports collectively.
Okay.
From Dr. Welcher and Mr. Burgess.
Did Mr. Burgess make any adjustments from his original report to his subsequent report in May of 2025?
Yes.
Let's go to slide 6, please. Tell me about this slide.
Yeah, so this is the first adjustment we're going to talk about that was, and this one comes from Mr. Burgess's original report. And to summarize this adjustment, this is a key on timing adjustment, and we're going to show that the key on, the actual turning of the vehicle on, occurs about 3 seconds before that time gets registered in the infotainment. So the time we see is basically stale by 3 seconds.
We're all familiar with how computers turn on. When you say key on, do you mean a physical key, or could it be the push button to turn the car on?
In this case, it's a button. I refer to key on because generally that event is considered the key on in vehicle parlance, regardless of whether there's a physical key or it's a push button.
So those 3 seconds mean what? What's the difference between pushing that button and the 3 seconds later that you just described for each of those?
It means that when we're trying to use the timestamps that were recovered from the infotainment system that show when the vehicle was keyed on or turned on, that the vehicle was actually or likely turned on 3 seconds before that.
Do you know where the 3-second conclusion came from in Mr. Burgess's report?
That came from the testing that Aperture conducted with the exemplar Lexus that they purchased.
Was there anything in the report that indicated testing, this type of exact testing on Ms. Reed's actual Lexus?
No.
Do you have an opinion as to whether or not all Lexuses, at least of this make and model and year, would have the exact same 3-second delay? Or could that be different?
It could be different in their testing with in their testing, they only tested one exemplar vehicle. So I think there was a solid foundation that the exemplar that was used exhibited this 3-second delay. It was a very close match in terms of part numbers and software versions to Ms. Reed's Lexus, but without any kind of testing of, let's say, a second vehicle, a second exemplar, we wouldn't know, we wouldn't have any basis to say it must be 3. We could test a second vehicle and it could be 5, so we say, well, there's a delay, but it varies vehicle to vehicle. They could have tested a second vehicle and found it's also 3, and then you start to build some confidence that maybe it is 3 across every vehicle. But with only testing one and not testing the subject vehicle, it is difficult to say with absolute certainty it would be 3 seconds.
What is your opinion about best practices with regard to trying to create this gap for purposes of coming to an opinion or an analysis?
So because we don't know whether or not this specifically would apply to Ms. Reed's vehicle, the best way to conduct that analysis would be to do the entire thing with the key switch adjustment at 3 seconds. Because if we're going to use a value, 3 is the most reasonable one because that's the one shown in testing. But we should also do the entire analysis without it in case we feel that that's the most appropriate. So, in fact, that's what I do and will show is I ran the analysis both ways, with and without, to be as conservative as possible.
Did your review of Mr. Burgess's report indicate that he ran the analysis both ways?
He did not.
Let's go to slide 7. What are we looking at here?
This is an excerpt from Mr. Burgess's original report, his page 28 and his page, there's a screenshot also from his page 30 at the bottom. And this is where he states in that report that when they were doing the testing with the exemplar, they observed across 4 different key-on cycles this 3-second difference. So what I mean by that is they had a video camera in the car that had a timer on it. And so in the video, you can see the button pressed. So in their testing, for example, they pressed the button at 21:48:05, and that's sort of nailed down. When they went back and downloaded the data from the infotainment, the key-on was logged in the infotainment as 21:48:08. So there's the 3 seconds. That's where they're getting that from, and that's what he states highlighted in red there. It's a little hard to read, but it basically says the average across 4 runs was 3 seconds.
The 3-second delay, was that actually in his report?
This is the only point in the report it's mentioned.
I guess what I'm asking, it was an inartful question. The portion to the left, is that his report or your report?
That is his report. Everything on the left-hand side of this slide comes from Mr. Burgess's report.
So the 3-second delay was noted in his report?
It was noted.
Did he apply the 3 seconds in his analysis?
He did not.
Did he indicate in his report why he ignored that 3-second delay?
He did not.
Sustained as to that question.
I'll rephrase it.
Strike the answer.
Did he indicate in his report the reason that he did not apply the 3-second correction?
He did not.
When you do apply the 3-second correction, what do you come up with as it relates to the 26 seconds from the end of the recording?
So the positive 26-second window, if we only apply the 3-second key on, grows to positive 29 seconds.
If you applied the same 3 seconds to the trigger event time, now what does the gap?
That gap would grow to a positive 34 seconds.
Between the trigger event and what?
The phone lock.
In your opinion, was it best practice to not account for that 3-second delay between the on switch and the data coming on?
Sustained, ask you differently.
what, in your opinion, would be the best practice in terms of this 3 seconds that was noted in the exemplar vehicle?
The best practice would be to run the analysis with that adjustment included and without that adjustment included. Because like I stated, without testing of an additional vehicle, we really don't know if the 3 seconds is just a specific behavior of that exemplar or if it's representative of all Lexuses of this type.
Let's go to slide 8, please. Tell us what we're looking at in this slide.
So now we're going to get into the next adjustments. That first adjustment we just talked about was really a vehicle-to-vehicle adjustment. We haven't talked about the phone yet. We're going to get into the phone now and talk about aligning that. But we had to get through the internal adjustment that has to get done first. Now we're going to look on the subsequent slides here at all of the different ways the Aperture reports compared the vehicle to Mr. O'Keefe's phone.
Is there any additional adjustment that you believe should be made?
The Aperture reports lay out 2 methodologies for adjusting. There is a methodology based on phone calls, and there's a methodology based on the 3-point turn.
And where did you get that information from?
From the Aperture reports.
In Mr. Burgess's original report on differentiating, the January report, which did he use to determine his determination of the clock skew?
In his initial January report, he never actually takes the calculation to the end by applying the differences in times to the calculated time for 1162-2, but he does do the math, which I'll show, for the differences on these phone calls.
In terms of Dr. Welcher's report, did he identify a GPS point of 154 at all?
Yes.
How did he describe that GPS data point?
He describes in his initial PowerPoint slides as point 154 aligning with the end of vehicle event 1162-1, talking about a different event now. This is the 3-point turn event. So he uses that as an anchor point.
And that anchor point, you said, was the end of the text stream event, or the end of the recording of that text stream event.
Correct. The Aperture reports consistently reference everything from the end of the events.
Let's go to slide 9, please. What are we looking at here?
On the left is an excerpt of page 33 from Mr. Burgess's initial report. And what he shows here is he has identified 7 call logs that exist both in the infotainment from Ms. Reed's Lexus and in Mr. O'Keefe's phone. He puts them in a table form. Then he actually goes on and calculates the difference between those 2 times. So that's what I meant by he sort of does the math. He makes my job a little easier, and the numbers are already there. He just never applies these to any of the times. So that's where I step in and say, if I take that 3rd column that he lays out, those are in seconds. If I apply those seconds, that adjustment to 12:31:43, where do we end up with John's interaction window in those times?
What did you conclude in terms of finishing the work?
Sure. I did all of them. And so I highlight on this particular slide, I just highlighted the very first one he has in here. In that case, he identified that Mr. O'Keefe's phone was 2 seconds slow relative to the infotainment system. So if we apply only that adjustment, then John's interaction window becomes positive 28 seconds.
Did Mr. Burgess apply all of the potential offsets?
He didn't apply any of the offsets. He calculated all of them, but he didn't apply any of them.
Did you ultimately apply all of the offsets?
Yes, I did.
And what did you determine?
Regardless of which offset you apply, John's interaction window remains positive. the number changes, but it remains positive.
Let's take a look at those one at a time if we can. Let's have the next slide.
So in this slide, I just took the other end of the spectrum. There's a large range in values in this table. He doesn't actually, Mr. Burgess doesn't show the sign conventions on here, but actually—
What do you mean sign conventions?
Sign conventions, he doesn't show when he calculates the difference whether it's positive or negative. All the numbers in the table don't have a sign, don't have a plus or minus in front of them, but there's an implication. Some of them are plus, some of them are minus. So the first one that we just looked at showed we had 2 seconds slow. There's another value in here that's on the other end of that. It shows that Mr. O'Keefe's phone is 21 seconds fast now relative to the infotainment. So that's the largest value in the table we could take that would bring John's interaction window down now. And so if we apply just that adjustment, John's interaction window becomes a positive 5.
Take a look at slide 11, if we could, please. What are we looking at here?
So I've shifted now from the phone calls, and now we're going to talk about the 3-point turn alignment. And the 3-point turn alignment is first presented in Dr. Welcher's slide from his presentation here. And in this, he doesn't say it explicitly, but he provides some math on the screen, which is a little hard to read. But he puts some math on the screen that shows he's aligning this 0.154 from Mr. O'Keefe's phone to the end of event 1162-1. This is the prior event. This is a 3-point turn. And so he aligns, he says this is basically how you align it, and he doesn't do the math. Again, he lays out that he says a 19.2 second difference. I actually just adjusted that to 20, which is the most conservative way to interpret that. I don't think we have the accuracy here to talk about tenths of a second. Nevertheless, I just rounded that up to 20, and when we apply that 20 seconds to our event 1162-2, then John's interaction window becomes positive 6. That's just applying this. We're not combining anything. We're just applying the difference shown in this slide.
And that positive interaction window, is that calculated based on information directly from Dr. Welcher's report?
Yes.
Let's go to slide 12. What are we looking at here? What is this table?
This is a table I made. We've talked about a lot of different approaches to how these clocks can be aligned and a lot of different variables. So I tried to summarize them in one table, put them all together, because some of them we can combine. We can combine the key on with either a phone call or a 3-point turn, but we can't combine, for example, a 3-point turn and a phone call. That's not valid. So I put all the possible combinations, all of them, with, without key switch, phone calls, and 0.154 on one table, and I calculated John's interaction window for all valid combinations from the aperture reports. And when we do that, the result is that regardless of what adjustment we make, all of the numbers are positive, meaning regardless of what adjustment we make, the phone lock event always occurs after the end of event 1162-2.
Did Mr. Burgess, in your review of his report in January of 2025, did he ever undertake all possible offset calculations?
No.
In his May 2025 report, did he undertake all possible offset calculations?
No.
What is your opinion in terms of best practices regarding calculations of this sort?
I think if there's sufficient data, if there's testing or research or literature that in a specific case supports there is a best path or a best method, then we should use that. In this case, I don't think there is a best practice. There isn't any literature I'm aware of that would specify exactly the best path to align all of these. So in the absence of any external data to support one path, The most valid approach is look at all of them as a whole and then draw the conclusion from the totality of that data, rather than cherry picking a single point.
Can you testify to a reasonable degree of scientific certainty whether all potential offsets that were described in Aperture's original report, January of 2025, result in a positive interaction window?
Yes.
And what is that opinion?
Regardless of what adjustment or combination of adjustments we make from the original reports, John's interaction window remains positive.
Does the positive interaction window mean the lock event occurred after or before the text stream event?
It means the lock event occurs after the end of the text stream event, 1162-2.
You've already indicated that you received a second report, May of 2025, correct?
That's correct.
In that report, is there the same clock skew alignment or a different clock skew alignment that Mr. Burgess now undertakes?
Mr. Burgess undertakes a different alignment in that report.
Let's go to slide 13. Describe what we're looking at in this slide.
So what I have here on the left is a screenshot of page 42 from Mr. Burgess's supplemental report. And so now he's done two things new here. He's identified a new method for aligning the data based on the three-point turn. So now he's kind of following where Dr. Welcher started, but he's approaching it a little differently. And secondly, he is now calculating the actual time. He's doing the difference calculation and he's applying that to the time. So now he's taking the calculation all the way through, which is a little different from the prior reports. And so when he does that, he makes my job really easy because I didn't have to do really any math now. He comes up that there is a range now. So prior to this point, the original report by Mr. Burgess and Dr. Welcher reports all used discrete points in time, right? They sought to find an event that occurs at a singular second and another event at a singular second and align based on that. This is a little bit of a departure from that approach. Mr. Burgess is now using a range of times, a range of uncertainty. He basically assesses that the three-point turn data from the phone and the three-point turn data in 1162-1 cannot be precisely aligned down to a single point. Rather, they overlap in this range of seconds. And so he then says that that range must be applied. So now we have to apply a range. And what we end up with is 9 possible values. So it kind of looks like one conclusion, but really there's 9 conclusions on this slide. And so if we just applying the math he has in the supplemental report, John's interaction window now has a range of 9 possible values. And that range spans from +5 now to -3. So we have 5 positive values. We have 1 value that's 0, and the 0 would mean it's simultaneous. And then we have 3 negative values.
Does Mr. Burgess indicate in his report that any one of those values is more likely than any of the other values?
He does not provide any data or analysis to support one point being preferential over the other 8.
And are there more or fewer positive results in his analysis than negative?
There are more positive numbers in that range of 9 than there are negative numbers.
Does Mr. Burgess's new data indicate anything about Dr. Welcher's analysis about the GPS data point 154 being at the end of the three-point turn?
He opines in that aligning the three-point turn on a singular point is not, and I'm paraphrasing because I don't know the exact way he states it, but not the preferred method.
Is Mr. Burgess's analysis consistent or inconsistent with Mr. Welcher's determination that GPS point 154 was at the end of the text stream event?
Objection.
Sustained.
Does Mr. Burgess, in his report, indicate whether he agrees or disagrees with Dr. Welcher's analysis?
I don't remember specifically.
In your opinion, I asked you about Mr. Burgess's report. Now I'm going to ask you about your opinion. In your opinion, is this new offset any more likely or reasonable than any other offsets previously proposed by Mr. Burgess?
I don't think it is more or less likely. I think it is a valid approach, certainly. And so I think the results from the additional analysis should be included with the analysis of all of the results so far.
And none of those results are more or less likely than any of the others, correct?
Sustained.
Are any of the results, in your opinion, to a reasonable degree of scientific certainty, are any of the results any more or less likely than any of the others?
It's my opinion they're all equally weighted.
Did Mr. Burgess account for the 3-second offset that we talked about earlier in his May 2025 report, his new report?
I did not see any mention of that in his supplemental report, and certainly the 3 seconds isn't present in his math.
Okay, so Destination, what she actually ruled on yesterday was that Dr. Welcher could not be questioned on cross respective to the material that he included and seems to have adopted that came from other sources. That's what she ruled on yesterday. Because this witness is a direct rebuttal to what Shannon 1N and Dr. Welcher, he is allowed to reference both of their reports and the work that they did or did not do. I think that's where the confusion might be. Hopefully that makes sense what I just said. Sometimes it sounds better in my brain than it does coming out of my mouth.
I don't see it there.
Let's go on to slide 14, please. Describe what we're looking at here in this table.
This is very similar to the table we looked at previously, where I look at all possible combinations. Now, however, I just have a lot more data points to show, so I've had to break the table into two tables. So we're going to look at this, and then we'll look at slide 15 next, which is the second table. I just couldn't cram 30 lines onto one slide.
Let's move to the next slide then. Is this a continuation of the
second half? So think of these as a singular table. I just had to split them up. If we head back to slide 14, we'll start there. So this slide, I'm not accounting for the key on, and that's the main difference between my two tables. Table 1, I'm not accounting for the 3-second key on. In table 2, I am.
When you say key on, you're talking about that 3-second delay.
Correct.
Okay, go ahead.
But again, I want to make sure we're thinking about this as a singular table because that's where we'll draw our conclusions from. So the first lines of the table, we've already seen those. Those were in my original table. I haven't changed those. That's the same math that's been there. All I did was I added the 9 points now from Mr. Burgess's supplemental report using the range he shows. And so now we can see if we include that, now we get some positive numbers for John's interaction window. We get that 0. And again, the 0 would imply that the end of event 1162-2 is happening exactly at the same second as the phone lock. So it's kind of not on one side or the other. So I think it should be thought of as separate. And then we have 3 negative values, which would imply that phone lock occurs before the end of 1162-2.
And did you already mention the simultaneous, the one that was simultaneous?
When John's interaction window is 0, correct?
0.
That would imply simultaneity.
All right, is this 14 or 15? This 14, let's move to 15. Now, this is the continuation of that. Mentally, we'll just continue that same table?
Correct.
Okay.
Just a continuation. Imagine in your mind is just rows 16 to 30.
Okay?
And it's the same thing, same format, except for now we're just adding in that key on adjustment because, again, I think the analysis should be run with and without it. And so now when we run this with the key on adjustment, we get 14 of these 15 are John's interaction window is positive to various degrees, and one of them, it's 0, again, simultaneous, and there are no negative values with this adjustment.
Can we go to the next slide, 16, please? What are we looking at here?
This is the summary, then, of that table, kind of a verbal summary of the giant 30-line table now. And if we look at all of the possibilities from all of the Aperture reports collectively, then we can draw some pretty straightforward conclusions. 25 of those 30 possibilities result in interaction with the O'Keefe phone after the end of event 1162-2. Looking at all the possibilities, 2 of the 30 result in interaction where it's simultaneous. That's the zeros, they're present in both tables. And then looking at all 30, 3 of the 30 result in interaction with the phone before the end of event 1162-2.
Do you have an opinion as to which of these particular offsets that you've described, these 30 possibilities, should be applied in this case?
No.
Why is that?
Each of the approaches have their own individual strengths, and each of them have their own individual weaknesses. And there is not really any published literature, any research, or any testing done that I'm aware of that would suggest one really stands head and shoulders above another one of the methods. So I think the most fair way to present it is to look at, again, if we combine everything together, then we can draw some conclusions like this in terms of how many of the total result in one outcome or another.
Is every data point that we're looking at and that you've been talking about, are these all drawn directly from Aperture's reports?
That's correct. I have not proposed any methods for aligning the clocks myself. All of the methods that comprise these 30 are from the Aperture reports themselves.
Based on your analysis of the Aperture, or your review of the Aperture analysis, is there any ability to say to a reasonable degree of scientific certainty that the text stream event occurred after the last physical interaction with John O'Keefe's phone?
Yes, there would be three out of the 30 possibilities would result in that.
Do you have an opinion to a reasonable degree of scientific certainty that it did happen after the text stream event?
Objection. Sustained.
Of the 30, what's the percentage of possible events that occurred, possible scenarios, I should say, wherein the text stream event occurred after the last interaction with John's phone? What's the percentage?
That's sustained.
You said it's 3 out of 30, correct?
Yes,
Is that 10%?
that is 10%.
Yeah, it's sustained and it's stricken.
What the
percentage
hell?
is 3? Just do basic math for me. What is the percentage between 3 and 30?
Sustained.
If I told you hypothetically,
I'm going to see you type out for a second.
This is ridiculous. Let this man testify. Look, I know that this is really dry testimony, but for whatever reason, I get it. I hope. This is the way that I'm interpreting the testimony. All this gentleman did was use the data from the reports generated by Aperture, both Dr. Welcher and Shannon 1N Burgess. and actually did the math consistently. He used the same formula and the same, what's the word I'm looking for? In other words, when Burgess did the calculations and found, or didn't, let me start again. When Shannon Burgess compared when the exemplar vehicle is turned on at the time that a clock would say versus the time that the time that is registered with the infotainment center, there is a 3-second delay between those two times. Okay. And what he did not do is apply that 3-second window unilaterally, doing all of his calculations. Okay. And it would be, I suppose, a better way to understand that. Well, no, that's just how it is. It's on its face. So he sometimes he didn't even use the calculation. He performed a test to see what the delay was between the actual clock and when the timestamp, the time that the infotainment center registers, and found there to be a 3-second delay, and then proceeded to perform all manner of calculations on multiple different events that and didn't bother to apply the 3 seconds. And so because of that, he used bad data going in, so bad results came out. And then he said, I don't want you guys to miss any of this. And then when it came down to it, his ultimate conclusion was incorrect because he had not applied his own results from a test to the data. Right. There you go. He set up the equation but didn't solve for X.
Following your analysis of the totality of the possible scenarios, did you come to a conclusion that the vast majority, let me rephrase that, did you come to any conclusion about the numbers as they relate to the positive interactions versus the negative? And when I say positive versus negative, I'm talking about the phraseology that you used. John's phone interaction being in the positive side versus John's phone interaction being in the negative side.
Yes.
And what were those?
Of the 30 possibilities, 25 of them, it's a positive. John's interaction window is positive for 25 of them.
And only 3 were negative?
Correct. Only 3 of the 30 were negative.
Okay. Okay, we can take that slide down. Is there a data recorder on the Toyota SUV that we've been talking about, that 2021 Toyota SUV 570, that's designed to record impact?
Yes.
What is that? What is that mechanism?
That would be the airbag control module.
The ACM?
ACM.
Did
Correct.
you look at that?
I was provided a copy of the download from the ACM.
What did the data recorder indicate, if anything, related to any impact on January 29th, 2022?
There were no recorded events whatsoever on the ACM.
Did the vehicle control history record whether there was any history of a collision on that car, ever?
No.
What does the vehicle control history record specifically?
It records a lot of operational.
In that the vehicle impacted with a pedestrian?
No. No.
You reviewed the raw text stream data.
Hold on, Mr. Jackson. I don't want to interrupt you. So if you think about it, if you think about what Leslie said, he set up the equation but didn't do the solution. So he never actually did the math. He didn't solve for X. What this witness did was solve for X. He actually did the math, okay, multiple times. And if you think about the end result in terms of what the medical examiner testified to, John O'Keefe, if you listen, if the state's theory is correct and Karen hit John O'Keefe at the rate of speed that she did, causing that skull fracture when he hit the ground, he would not have been able to close his phone, lock his phone. Okay. That's what I think, that's really what they're basically getting down to. I'm going to rewind so we can hear Mr. Jackson's question. Okay, here we go. Sorry about that.
No.
You reviewed the raw text stream data associated with the entirety of Ms. Reed's vehicle, did you not?
Yes.
How many text stream events or triggers were found on Ms. Reed's vehicle during the course of the 8-month period prior to January 29th?
So can you narrow that, Mr. Jackson?
Sure.
I object to the whole line.
Shut up,
See
Brennan.
what's happening.
Oh my God. Hold on. All right. Let me listen to that question again about the
Sure.
module. Okay.
That the vehicle impacted with a pedestrian board,
Whatsoever.
look at the V570 that's designed to.
All right, let's start in here.
Is there a data recorder on the Toyota SUV that we've been talking about, that 2021 Toyota SUV 570 that's designed to record impact?
Yes.
What is that? What is that mechanism?
That would be the airbag control module,
The ACM?
ACM.
Did you look at that?
I was provided a copy of the download from the ACM.
What did the data recorder indicate, if anything, related to any impact on January 29th, 2022?
There were no recorded events whatsoever on the ACM.
Did the vehicle control history record whether there was any history of a collision on that car, ever?
No.
What does the vehicle control history record specifically?
It records a lot of operational.
In that the vehicle impacted with a pedestrian?
No. Records a lot of operational.
In that the vehicle impacted with a pedestrian?
No. No.
You reviewed the raw text stream data associated with the entirety of Ms. Reed's vehicle, did you not?
Yes.
How many text stream events or triggers were found on Ms. Reed's vehicle during the course of the 8-month period prior to January 29th?
So can you narrow that, Mr. Jackson?
Narrow
Sure.
it to what? That he did narrow it, 8 months. Crocheting Bammy says, see, if there's no impact, then that means that she also didn't hit John's car. I'm actually kind of curious about this. Because we know that she did. And I feel like there's a reason why Mr. Jackson asked that question. He already knew the answer to. So what I'm hoping for is a potential explanation, but I don't know if it will come in from this witness. Okay. And I think the point might be, and remember, they don't have to prove that Karen hit John's car. Okay. The state has to prove Karen hit John with her car. The burden is on them. And it might just be what they're proving here is that you cannot say either way. So if it didn't record her hitting John's car, and we can see that it happened, there's incontrovertible evidence of it. There's video evidence of her hitting that vehicle. Okay. Then there's no way that any expert could get on that stand and say that the download of any of the modules recorded an impact at all. Okay, so when the last question, one of the last questions that Dr. Welcher was asked on the stand on direct was if he had an opinion that a collision occurred, and he said yes. And I think that's the point. And I also think, Crocheting Bammy, that the defense is not arguing that Karen Reed's taillight was cracked. Because last trial, there was a witness who was called to the stand by the state or the Commonwealth, who was at Karen Reed's parents' house when her vehicle was he arrived ahead of the tow truck driver, okay, because it was his jurisdiction. It was a courtesy call. So he went out there and he said that the tail light was cracked, not broken, okay? And I think that the implication is that it was cracked and then somebody cracked it, broke it, and then took those pieces. That is the implication. So Tony says, so when you say we know there was impact to Karen's car, do you mean we know because the taillight was cracked? No, we know that there was one impact, or at least I think, okay, let me just put it like this. I believe there is video evidence that shows that Karen Reed backed up at One Meadows into John O'Keefe's vehicle. That's what I believe. Okay. So, and I believe that the defense also believes that Karen hit John O'Keefe's vehicle backing out of John's driveway at One Meadows. So that's how we know. It has nothing to do with the taillight. It has to do with that video. You can see when she backs out of that garage that John O'Keefe's car moves. I'm not sure why the collision is not recorded. Could it be because it was at such a low rate of speed that it doesn't record? Could it be that because the airbag didn't deploy, that it didn't record it? I don't know. Like, I'm not enough of a car person to understand why those modules don't record some things and why it records other things. You know, yes, Tess is right. I'm not
Mr.
sure.
Jackson, how much longer? I'm just
Oh my
trying to
God,
figure out if-
shut up. You see how she is? I'm not sure. Tess, I agree. We're not sure. We don't know if he's going to be called this trial. We don't know. Right. So Crocheting Bammy says, if they're talking about airbags, aren't they just in the front? Maybe it only records front collisions. Airbags, there are some vehicles that are equipped with the airbags we typically think of, right? Which come out of the steering wheel and then above the glove box on the passenger side, right? But there are also vehicles that have side airbags as well. So I don't know. I don't know enough about that kind of a thing to know. So I'm hoping that there will be some type of testimony giving an explanation. And here goes Bev. How much longer are you going to be? It's so rude, Judge Bev. Fuck off.
I'm wrapping it up, Judge.
Okay.
It's not going to be long. A
Jeez.
few more questions.
I'm not curbing you in any way. We just
Understand.
You are.
Respectfully, it
Hold
won't
on
be
a
very
minute.
much
You
longer.
are, Judge Bev, stop playing. This irritates me so to such an extent. Okay. You did not bring the jury in. I'm going to get all the way yelly. Turn your earbuds down. Please turn your TVs down and remove any children from the room. All right. You are trying to curb by asking. Okay? When you use the term, how much longer, it does come across that way, Judge Bev, and you know it. You're an educated woman. You're a judge, for the love of Pete. That means you went to law school. That means you passed the bar, okay? Which that joke writes itself. I'm going to leave it there. All right? No, I'm not. Which you haven't done since. I haven't passed any bars since. Anywho, it's rude. It's rude.
You reviewed the tech stream data, otherwise known as the triggers, for the entirety of Ms. Reed's vehicle, correct?
Yes.
How many trigger events did you find in the life of the car?
Not counting 1162-2.
Let's stop there. Right.
Prior to 1162-2, there were 19 prior events.
And 19 total events, correct?
Correct.
And how many collisions were clocked by any recorder on that car?
None of the events were triggered by a collision.
And last question, do any of the tech stream events or do any of the data that you've reviewed, either yourself through Mr. Burgess's report, through Dr. Welch's report, do any of the data indicate that there was a collision on January 29th, 2022 at any time?
Objection.
ask it differently.
What did you find in terms of, I want to narrow this question to January 29th, 2022. What did you find in terms of any data regarding a collision?
Neither of the events that occurred on that date were triggered by a collision.
Thank you. May I have just a moment, Your Honor?
Okay.
That's all I have, Your Honor. Thank you.
Okay. Jurors, we're going to take the morning recess.
Yeah, Judge Bev needs to get to her Misties
We'll have you come back at 12.
where she gets the shakes. She just irritates me on a level that makes me lose my mind. Okay, so while they're on a break, I want to show you this because Tess sent me this. Meanwhile, somewhere, Dr. Welcher's doing this. Apparently, he's from the east side. Oh my God. I I cannot. Okay, first of all, let's break this picture down. I can't take somebody who is in a paisley robe, which I'm assuming, judging from what's going on in the background over here that you can see in the reflection off of the door. It looks like it's a present and he's showing off his present, but bruh, go on somewhere, Mr. Welcher. For really. Okay. Now, that being said, let me read you guys the Commonwealth's response or let me just read their motion to preclude the witnesses that are Proctor's friends. Okay. It says Commonwealth's motion to preclude inadmissible hearsay. The defense noticed that it intends to call 4 individuals who have phone numbers associated with a federally protected and confidential series of text messages from Michael Proctor's personal cell phone. The defense intends to offer the communications of 9 individuals, only 3 of whom had partial contact names saved within Michael Proctor's personal cell phone for the substantive truth of those statements. Of note, the confidential record indicates that there were a total of 38,707 text messages exchanged within this group beginning on October 18th, 2021 and ending August 31st, 2022. The defense seeks to introduce a limited portion of text messages unattributed to being, The defense seeks to introduce a limited portion of text messages attributed to being exchanged by 9 individuals that occurred over 3 years ago. There we go. That's much better, Jen. I had to scroll a little bit bigger. Preliminarily, it is the defendant's burden to satisfy the requirement of authenticating these communications by producing sufficient evidence to support a finding that the communication is what the defense claims it to be. The defense must not only establish that the communication was authored by the witness on the stand, but also the statements, let me make sure I'm not muted. Okay, good. But also the statements of others in the group, including Michael Proctor. This will require the judge to determine relevance and admissibility of each communication depending on who authored the communication and whether it is sufficient for a reasonable jury to find by a preponderance of the evidence that each and every communication was authored by the individual member of the group. Of note, prior to authentication, no communications should be displayed or read to the jury. Furthermore, the text messages contain hearsay upon hearsay. Oh no, it's a hearsay inception. And each statement and text message must conform with an exception to the hearsay rule. There are no applicable exceptions. Michael Proctor is available to testify and could authenticate and perhaps adopt and acknowledge the statements sought to be introduced. Massachusetts does not recognize a residual exception to the hearsay rule. While Bowden, quote, preserves a defendant's right to attack the adequacy of the police investigation, that attack is still constrained by the rules of evidence. Nothing in the Bowden case authorizes a defendant to introduce otherwise inadmissible hearsay. And it's the case citing is Commonwealth versus Raposa. Further, the quote, exclusion of evidence of a Bowden defense is not constitutional in nature and therefore is examined under an abuse of discretion standard. And there's more citings. Moreover, the statements are inadmissible for the purpose of showing Michael Proctor's state of mind, nor the state of police knowledge. Quote, hearsay testimony to explain the reasons for police action, however, carries a high probability of misuse because a witness may relate historical aspects of the case, replete with hearsay statements in the form of complaints and reports, even when not necessary to show state of police knowledge. Internal quotations omitted. Therefore, out of context statements to a police investigator, in this case attributed to Michael Proctor, in his capacity as the case officer assigned, are permitted: one, only through the testimony of a police officer who must testify only on the basis of personal knowledge; two, is limited to the facts required to establish the officer's state of knowledge; three, is allowed when the police action or state of police knowledge is relevant to an issue in this case. So I'm going to say this, okay? I'm not an attorney, so I can't tell you whether this has merit to it or not, if these arguments are salient, if they are applicable and whatnot, because I'm not an attorney, okay? I don't, and in order for me to understand it, I'd have to be an attorney, but that would be at the highest level of understanding. But at a lower bar setting, I would have to go and research those case sites and then understand those. And I'm not an attorney. So basically at this point, based on Judge Bev's other rulings respective to them presenting any witnesses to speak to the type of investigation that was conducted by former trooper Michael Proctor, and she didn't allow that in. I'm gonna say I don't think that she's going to allow this stuff in. That's just my guess. Just, based on the brand that is Judge Bev. Okay. Now, so I think it's ridiculous. I do agree with Tess. Tess says they are trying to make the defense call Proctor by not wanting them to call these guys. I agree. I think that they're going to try to force the defense's hand and have to call Trooper Michael Proctor. But even if they were to call, the way that I understand that motion or that filing, even if they were to call Trooper Proctor to authenticate these communications, the communications in and of themselves would be inadmissible because of the hearsay upon hearsay, which is what now, if that's the way the judge finds. I don't know what's in these communications, and I don't know if there is some type of hearsay exception rule included in those conversations. I don't know. I don't know if the conversations, let me just put it a different way. I don't know if the substance of those content of those communications, those text messages, would fall under any exception to the hearsay rule. So I don't know how I just don't think it's gonna So Tess says, how can they not allow something that was allowed previously? Well, it's kind of like, okay, so let's say that, let's take a different trial, for example. So at the conclusion of the trial, the defendant appeals the conviction. The first thing they do is they file a transcript of the entire trial, right? And then they go around, look, and then they look at and they cite all of, like, for example, errors when the judge made a ruling, okay? And those things, those can, and let's say that they one or two of those have merits, and the judge's ruling is, is deemed that an error. Okay, the way that the judge ruled is an error. In theory, a judge who allowed something in the first trial might say, "Ooh, you know what? This might be grounds for an appeal," or I ruled in error, and decide that they don't want to allow it in this time. I don't know. I just feel like because the judge in this case, like, they were okay to come in when the state wanted them in, right? Or it's just the thing about Judge Bev is the only thing predictable about her is that she is not predictable. And so it's it's hard to call it. So Crocheting Bammy says, I think the jury should get the transcripts of the first trial. The more info they have, the better. That would never be allowed. That would never be allowed. They're only allowed, okay, to base their verdict upon the evidence as it's been presented in this trial. The closest that they can come to hearing anything about what occurred in the first trial, and there is when a witness has changed their testimony between the two, and they won't even refer to it as a trial. They refer to it as a proceeding, and that's it. So, yeah. All right. So, from Turtle Boy about jurors. Thank you, Tess. Jurors look aghast. I love that word. They look like they are just realizing they've been lied to this whole time by Hank Brennan. Yeah, but sometimes she throws a curveball in, Nate. Sometimes she rules in a way that shocks me. Like, she might sometimes rule for the defense, and it shocks me. That's just me. I think the way that witness just testified, I think it's much more palatable and easier to understand for the jury. I think that the way that he explained it, in that he didn't come up with anything new. All he did was use the data from the aperture reports and actually did the math and then checked the math and applied the same formula across the board, where Burgess was like, I think for one, I'm going to solve, I'm going to use the formula for getting area, which is length times width. And then in another, I'm going to use the formula that is used to calculate volume, length times width times height. And, you know, yes, the data is the data, right? But if you're not, if you're supposed to be solving for X, and you all of a sudden remember, oh wait, let me put it like this. Remember when you had in algebra the double parentheses, right? And you have to use the method FOIL to solve, right? To break the equation down into a way that you can solve it, and you do first, outer, inner, last, okay? And then all of a sudden he just goes, there's an absolute formula to solve this equation, and he's out there just then, instead of using FOIL, he's throwing in the Pythagorean theorem or something like that. That's like the way that I took it. And I also don't understand why you would bother to do a test that shows there's a 3-second delay and then not apply that 3-second delay in your equations. I don't understand that. And I think that because I came away from listening to Shannon Burgess and Dr. Welcher's testimony, and honestly, I didn't understand anything that they were talking about, really. I didn't understand their point. I didn't understand how they arrived at any of their end results, because of the way that they testified. Even on direct. Exactly, crocheting Bammy. If you don't use the same methodology throughout the entire the equation, then the answer is wrong, period. And this too, Lucid Dream says, Duty Ron and Ed Wallace have videos about this case. Ed is a forensics expert in over 300 cases. They break down the forensics and failures of the witnesses. Yes, I listen to Duty Ron and Ed Wallace about this case quite frequently. I enjoy the banter that exists between them, and I love when they explain. See, it's one thing to say something is incorrect, okay? It's another thing to say it's incorrect and here's why. And I always appreciate the it's incorrect and here's why part. That's important to me, right? Like I feel, I love them both. And I really do love Ed Wallace as well. So I'm over there frequently listening to all of that. And I always appreciate it. But yeah, hold on a second. I've gotten the same email. Bindi, you're cute. Que linda. Thank you. I appreciate that, Rachel. Give me just 1 second. I need to know the why. this is really important too. Lucid Dream says they are retired police detectives and don't agree with this case or the way forensics was done. Protocols and procedures were definitely not followed as if they would be in the way they would be in other cases. Yes. And one of the things that Duty Ron and Ed Wallace talk about with respect to protocols and procedures is not only were they not followed in this case, but how they should have been, what they should have done instead, the proper way that this should have been investigated, the way the evidence should have been collected, how it should have, all of those things. For example, one of the things that Ed Wallace vehemently disagrees with is when the crime lab technician took scrapings of the debris on the clothes, okay? Rather than say scrape some of the debris from the shirt and collect it and keep it separate. What she did was she collected the debris from the shirt, the sweatshirt, the pants, and put it into one envelope, collected it into this, and her reasoning for that was, well, they were all commingled in the first place, which I understand, but when that's analyzed, that debris, okay, all the debris may not be the same, okay? And if it's not the same, because you jumbled it all up together like that, now we don't know if where the debris originated from, which article of clothing the debris originated from. And I think that that's a problem. And I just think it speaks to the level of no F's given in this case. And it makes you wonder how, if this is their work ethic all the time in all the cases, right? Like it's actually kind of scary, when you think about it. Because what is a criminal trial of this magnitude about, really? Somebody lost their life. Somebody's life was taken from them. Okay. And somebody else, and then conversely, somebody's freedom is on the line. So you want justice for the person whose life was taken, but you want that justice to be served to the right person, not just any person, the right person. And it's very, 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 very frustrating in this case when you see that the attention to detail, the just willy-nilly of, oh well, yeah, we're accredited, and oh yeah, we do all of the things, and I know that I rewound back. I know when I can see, so don't worry. I'll make sure to get us back right on time. It just works better if it has to load a little bit. And I just feel like when you see this kind of situation occurring, like, you have to say something. It's sad. John O'Keefe deserves better. Period. John O'Keefe deserves to have the best, and everybody does, but we're talking about this case. John O'Keefe deserves to have the best investigation done to reach the correct conclusion. Otherwise, it can't be justice. If there are there are always going to be questions at the end of every trial, right? Like, look at us. We all agree that Letitia Stout was the right person charged with the correct crime. Okay. That should not be a question at the end of a trial. Okay. Our questions that linger after Letitia is, what is the truth about that candle story? That candle is important because it's the one detail that she is consistent about. She mentions it over and over and over and over. So there's that candle has something to do with something. I just don't know what it is yet. And I don't think we've heard the truth out of her yet about that. But that's a very different question than than questioning, is the right person did the crime happen the way the state says it happened? And is the right person being charged with it? Okay. That's not a question you should have at the end of a trial, period. Especially a trial that we're on the 24th day of testimony. Rachel said, yes, Rachel. Rachel said, and what's wrong with her? Because it's not what Dr. Lewis said. It show ain't. It show ain't. Let's see where we're at here. All right, Tess sent me something else. Hold on. Let me get over here to see what my pal Tess sent me. Let's see. All right, so there is a poll. Let me just save this. Hopefully this comes out well. This was the poll yesterday on Court TV, and these are the results. So let me show you guys this. All right, grade the prosecution's case against Karen Read. 7% of people voting gave the prosecution an A. 8 gave them a B. 26% gave them a C. And 59% gave them an F. Now, of those, I would like to understand, I think C, these people are reasonable. They agree that it wasn't perfect and it wasn't even good. It was just aight. Okay? I need to know what these people up here are doing, these 7 and 8% up here who think it was an A or a B. I mean, even if you believe that Karen Read is guilty, certainly you can agree that that case was caca. They have, except Vinny. Vinny hasn't been. I think Vinny has said some things that I would not classify as anti-Karen. But it's, it's interesting. Hold on a second. I think Leslie's saying that she voted and gave them an F because there was no choice but there was no option for giving them a D. Yes, you're right, Tess. He did. He did. He was more anti, but recently he's become more. He said some pro things. He's kind of trying to stay in the middle of the road. So, and of course he does want to have, the views and stuff. So it is, but the thing of it is, I think anyway, whether you have a view one way or the other, right? If you are either anti-Karen or pro-Karen, right? and that's just strictly how you are. The people that are pro Karen, if you're anti Karen, people that are pro Karen will come over to an anti Karen stream just to voice their opinion. And conversely, if you're pro Karen, people from the anti Karen movement will come over and voice their opinion. So, I think the opinion you should have should be the opinion based on the evidence. And I do think that Vinny does also try to be unbiased. There are some times when generally speaking, I'm mainly am a fan of Vinny Politan. I have been for a very, very long time. I've always liked Vinny. I don't know why. He just, I just do. Okay. And so, yeah, I just like Vinny. I mean, Lucid Dreams, I could not believe that Dr. Welcher was allowed on the, to be answering his notifications with smartwatches. And here's why. Okay. He can say that all that he gets notified of are emails. All right. Well, anybody that has handled any type of smartwatch, smartphone in the last, 5 years, let's say, knows that when a notification comes in, you get a preview, especially if it's an email. It'll tell you who it's from, and it'll give you a few lines of the email. So anybody that has an intention to communicate and they know that the person they're communicating with is only getting their phone isn't on them, and they're only getting notifications of emails, knows exactly how to formulate a email to get their message across. And I think that it should have, I think he should have not, I don't think he should have been allowed to wear his smartwatch. I think that a smartwatch should be treated the way that a cell phone is treated, because now these watches are capable of doing the same thing that a phone is capable of doing. And so in that regard, so I think it doesn't just display time. And if you need to know what time it is, then I don't know, if you're a witness and you need to know just how long you've been on the stand, then scoot your chair forward and lean your body forward. There's a running clock at the judge's bench. If you just absolutely, I'm sure there's a clock in the actual room, in the actual courtroom, if you just have to know. But I think that they should treat smartwatches the way they would treat the way they would treat a phone. It just shouldn't be allowed on the stand. And I just think that should be a rule now. We have to change the rules, based on technology, So it's just what I think. Whew. Court is on morning recess, back at 12. It's 12:01, Judge Bev. See, this is my problem with Judge Bev. She's in a hurry to get to the break, but she's never in a hurry to come back from the break. She doesn't want to keep on that strict of a schedule. I mean, the whole situation with Aperture is sketchy AF anyway, okay? Because they're, changing formulas, doing different calculations, all during a trial. This stuff should have been already done and completed. It's ridiculous. You're right, Tess. Look at the difference in demeanor between the Aperture guys and Matthew. It's so, and even Matthew says things like, I'm limited on what I can say. I'm limited to what I could testify to, all the things, which I think is good, where the Aperture gentlemen were like, oh, hell yeah, I can totally make a flux capacitor and we can do time travel. I'll do it right now. You know, anything's possible. It's ridiculous. And also, I need a human break. All right, I'm going to mute you guys. I'm sorry. I tried to hang in there, but I gotta have a human break. I'll be right back. Hopefully the court, here they go. They're coming back. I'll just wait. Let's go, Judge Bev. Yeah, go to space with my load. 88 miles an hour. That's what I kept waiting for him to say. You know, I kept waiting for him to show a video of his lab with 11 billion different clocks all set 20 minutes behind. You know, like that's what I kept waiting for them to show. Like, it was ridiculous, that witness. Yeah. Let's go. Call it to order.
Back in session, you may be seated.
All right, Mr. Brennan. And Mr. DeSogra, I'm going to ask that you keep your voice up because we're going to try and keep the air conditioning on. And the fans, it's a little stuffy in here, so if you just speak directly into the microphone, that would be great.
Not a problem, Your Honor.
Thank you.
May I proceed?
Please.
Good morning, sir. Good morning, sir. Sir, are you trying to offer an opinion suggesting that Ms. Reed's Lexus never hit John O'Keefe on January 29, 2022? Objection.
I'll allow it. Is that what you're doing?
Is that your opinion?
No, sir.
Are you offering an opinion that Ms. Reed's Lexus never got in a collision before?
The way I stated it was none of the prior events were triggered by a collision.
What I'm asking you, are you offering an opinion that Ms. Reed's Lexus never got into a collision before January 29, 2022 or on that day?
No.
So when you were talking about collisions to the jury, you weren't making any suggestion that that Lexus was not in a collision, were you?
I think you threw a double negative in there. Can you just clarify what you meant? Yeah.
You are not suggesting to this jury that Ms. Reed's Lexus did not ever get in a collision before?
No.
Okay. You're just saying that there's no data on the text string to suggest a collision.
Specifically, none of the events were triggered by a collision.
Right. That's text stream data can be triggered by a number of different things other than a collision. Isn't that true?
Correct.
And in fact, when you talk about text stream data, you know that text stream data does not record a collision. You know that.
A collision is not one of the triggers. That's correct.
Right. So when you were saying it wasn't triggered by a collision, it's never going to be triggered by a collision ever on text stream data.
Not the collision in and of itself, correct?
Right. Mm-hmm. Right. So there's other things that will trigger text stream data.
Correct.
Like sudden acceleration.
The only acceleration trigger that I'm aware of on text stream is if there's a large acceleration during what Lexus calls a PCS or a pre-collision safety event. But a large acceleration on its own, I do not believe is one of the triggers.
Are you sure you know a lot about text stream data?
Yes.
Sustained.
Do you know a lot about text stream data?
Yes.
And you're saying that if a car accelerates over 30%, in and of itself wouldn't initiate a trigger?
I'm not sure I understand.
You just said pre-collision is the only time sudden acceleration, from your perspective, would cause a triggering event. Now, I'm asking you.
I'm allowing this.
I'm asking you, if someone accelerated Ms. Reed's Lexus at over 30% acceleration, would that cause a triggering event?
I am not sure what you mean by 30% acceleration.
Accelerator, 30%.
Accelerator pedal.
Yes.
Oh, yeah, there's a lot of triggers there's a number of ways that these VCH events can be triggered based on the accelerator pedal angle. I think, is that, yeah.
And what is the percentage from your experience that would create a triggering event?
There's various. Toyota, Lexus calls it high, medium to high is what they put it.
Do you have a number? Do you know the actual data on what percent of depressing the accelerator on the same Lexus as Ms. Reed's would create a triggering event? Do you know?
Off the top of my head, I don't know the exact percentage down to this percentage point, no.
There is something different than the text stream data. That's the EDR data, correct?
Yes.
You would not expect, it would be abnormal for the EDR to register data based on a side swipe between a 6,000-pound Lexus and a 216-pound person, wouldn't it?
Objection.
I'll allow it.
That would be abnormal to register that data into the EDR, wouldn't it?
I don't know if I would use the word abnormal, but I would state it that there's a minimum threshold to record in the EDR, and a pedestrian impact generally wouldn't meet that.
I'm sorry.
A pedestrian impact generally wouldn't meet that, but I don't want to make a blanket statement as if it's always the case.
You're saying it would meet that?
Would not.
Would not. Okay. And a side swipe or a clip has less force and impact than a head-on collision, depending on the speed, correct?
Generally, yes.
When you are discussing the triggering event, that is the moment that something registers to the car to capture data in the text stream, correct?
Correct.
So if I was to suggest 30% of depressing the accelerator pedal would cause a triggering event, would the triggering event be when it reaches 30%?
Yes.
The event data captures potentially part of an event, doesn't it?
I think we're into semantics a little bit, and I think it depends on what you mean by event.
Exactly.
Because previously we'd been talking about an event as the data, but event can mean a lot of other things.
If an event's only 3 seconds long and 10 seconds of data is captured, then the data will capture more than the event, correct?
Correct.
If the event is longer, 15 seconds, 20, 25 seconds, and the data is only captured for 10, the text stream data only captures part of the event.
Correct.
Fair to say?
Very fair.
So when you're looking at the data, it doesn't tell you about the entire event, correct?
The data only tells us about the window of time the data captures. There's no way to know beyond that from the data.
All of your equations and pluses and minuses and graphs you're talking about deal with the 10-second text stream data that was captured, correct?
They deal with event 1162.2, right, and the 10 seconds it's comprised of. Actually, they really just deal with the end of the event. That's what everything in the Aperture reports reference.
Fair enough. But it doesn't deal with anything that could potentially happen after those 10 seconds, does it?
No.
Or anything before?
No, it does not.
The triggering event is spot in the middle, captures 5 seconds before, 5 seconds after.
Approximately 5 seconds. It's not exact.
And you would have to look elsewhere for evidence to know what might have happened before. Yes?
Correct.
And you'd have to look elsewhere for evidence to see or determine what happened after.
Yes.
Do you know at the end of this triggering event, that 10-second window of data, do you know what happened with the defendant's Lexus after that 10-second of data?
No.
You have no idea, right?
I don't.
Okay. I want want to just ask you some questions about your background and then leading into this case, if I could. You have a bachelor's degree and a master's degree.
That's correct.
You've worked for your company for some time.
Coming up on 13 years next month, correct.
You've advanced through the company.
Yes.
You presently are the Director of Engineering.
Yes.
Are you ACTAR certified?
No.
What is ACTAR?
ACTAR is a body that basically offers a certification in accident reconstruction.
Do you offer services as an accident reconstructionist?
Sometimes.
And you have been hired and come into court and offer opinions as an accident reconstructionist?
In the singular time I've testified in court, it was not specifically for accident reconstruction, it was data analysis.
Okay. You continue your education and you go to a number of different trainings and seminars as well as teach, correct?
Regularly.
And when you regularly go to continuing education, you have quite a bit of continuing education that you've been through, haven't you?
Sorry?
You've been through quite a bit of continuing education.
Yes.
You focus, as part of your specialty, on EDRs, don't you?
That's correct.
Event data recorders?
Correct.
In fact, when you promote your services, that's one of your real specialty, isn't it?
Correct.
And it's something that not only are you schooled on and you go through continuing education, you're well published, aren't you?
That's correct.
And in your publications, you speak primarily about EDR type information.
Yes.
And that's something you are well skilled in, isn't it?
Yes.
Now, forensics or data forensics is a wide field, isn't it?
It is.
And you can do some things or many things in it, but oftentimes people specialize in parts of data forensics, don't they?
Generally, yes.
Well, speaking of you, you specialize in EDRs, true?
Yes.
There is a difference in different subspecialties, isn't there?
In general,
Oh, yes.
yes.
Okay. Now, are cell phones, is that a subspecialty in digital forensics?
Yes.
Is that something you're a specialist in?
No.
iPhones, are you a specialist in iPhones?
No.
Have you ever taken any specific training on mobile forensics?
No.
Have you ever written any papers on mobile forensics?
No.
Hey, have you ever promoted yourself of having any type of subspecialty as an expert in mobile forensics?
Never.
In any of your continuing education, and you have a vast amount, have you ever taken any classes or seminars in mobile forensics?
No.
Have you ever taken any class or study about variances between infotainment systems and mobile forensics?
Classes? No.
Have you ever attended any seminars on variances relative to mobile forensics?
No.
Have you ever testified about variances in mobile forensics before you testified in this court today?
No.
Have you ever published anything to do with variances in mobile forensics?
No.
In this case, you had an opportunity to review a number of reports from Dr. Judd Welcher, yes?
Yes.
And Mr. Shannon Burgess?
Correct.
In reviewing those reports, you've offered your opinions and analysis. Did you ever engage in actually any efforts or study in this case to obtain data?
Could you maybe clarify what specifically you're asking?
Yes. Did you ever yourself, not watch someone else do it, did you ever download or obtain data in this case?
No.
Did you ever test Miss Reed's car?
No.
Did you ever get an exemplar vehicle to run any tests?
I did not.
Did you ever do any actual testing in this case?
No.
And so your role is to look at other people's work and offer opinions and criticisms, basically.
And provide some clarity to the work, but generally, yes.
Clarity for who? Who asked you to provide clarity?
My clients in this case.
You what?
Mr. Jackson,
Right, okay.
my client.
Did you ever speak to me?
No.
As an expert, when you analyze data, whether you actively got it yourself or not, do you ever give an opinion in paper called a report? You ever write a report?
Yes.
And you've seen reports in this case that you've looked at, correct?
Correct.
A number of reports by Mr. Burgess,
Correct.
report by Dr. Welcher,
Also correct.
reports that you're critiquing, right?
Correct.
Did you see Ian Whiffin's reports?
It did not.
How about Jessica Hyde? Did you see her reports?
I did not.
You were asked to consider information from Mr. Whiffin's report.
No.
Well, you were asked to assume that the last user interaction on John O'Keefe's cell phone was 12/32/09.
That was stated in Dr. Welcher's report, so I started my analysis at that level.
So none of the information did you actually personally go and vet or analyze or make any determinations about. You're just critiquing written reports.
Correct.
Well, as an expert coming into court and testifying and having opinions, you put together a PowerPoint, didn't you?
Yes.
Why didn't you ever put together a report to share the basis of your opinions and the process you went through to arrive at your opinions before you came into court?
Primarily, I wasn't asked to, so I didn't do it. I wouldn't commission work without being asked to do it. And number two, the extent of my work beyond building the PowerPoint was just basic addition, just adding numbers together that already existed in the Aperture reports. So there wasn't a tremendous amount of complexity to what I engaged in.
What about your work product and your calculations? Did you do all this in your head, or did you type it out and go through a computer program? How did you do it?
I used a calculator for most of it, and the tables in my PowerPoint were generated in Excel, which has some calculation capabilities.
Were you ever asked not to write a report?
No.
You had provided an initial PowerPoint,
Yes.
and then you received information from Mr. Burgess,
Yes.
and then you added new slides to your PowerPoint.
That's correct.
Mr. Burgess's report was May 8th.
Yes.
You provided your PowerPoint on May 25th.
Correct.
Okay. Did it take you that long for the calculations between when you got the report and May 25th to put together the new presentation?
No, it didn't.
Why did you wait until May 25th to provide the new information?
That's when I was asked to do it.
What do you mean by that? I just want to see what the date is today. Today's the 30th. When you finished your PowerPoint on May 25th, did you send it to the defense on May 25th?
Yes, I did.
But they had a copy of your PowerPoint on May 25th. Don't be shy.
No, I'm pretty sure it was the 25th.
So it's sustained.
Yeah, if it wasn't the 25th, it would have been maybe the day after, but it's dated the 25th. I'm almost positive I provided it on the 25th.
There's
Yeah.
no reason for you to hold on to it for a couple extra days.
No, I think it was the 25th.
Do you know when it was provided to the Commonwealth, that report?
No, I don't.
In the 25th, the report that you provided to the defense on the 25th, it had new information in it, didn't it?
It had the information from Mr. Burgess's supplemental report. That was the additions.
Why did you wait until the 25th to put it together?
That's when I was asked to do it.
Who asked you?
My clients, Mr. Jackson,
He said, please add this on the 25th.
we had a phone call on the 25th and discussed Mr. Burgess's supplemental report. During that phone call, he asked me to update the presentation, and I did so, and then provided it.
How did the date of the 25th come about? Why the 25th was the date you provided?
That's when he requested it. I think it was a Sunday, actually.
Okay. When you first got involved in this case, it was last fall,
Correct.
and at that time, you received some information that Mr. Burgess wanted to look at the text stream data or the different modules on what you later learned was the defendant's Lexus, correct?
Correct.
There was a proposal from Mr. Burgess. Mr. Burgess wanted to go back to the car and look at the modules and try to download more information from them, correct?
Correct.
And you then got involved to look at what his request was, the procedure that you wanted to follow.
Yes.
When you did that, were you given any materials about what had happened before you and Mr. Burgess both got involved?
I don't recall specifically, and I don't think so. I think I was just provided the notice of testing that was to be done.
Well, you ended up drafting an affidavit.
I did.
And in drafting an affidavit, you pointed out some oversights of Mr. Burgess, didn't you?
I did.
Determining the oversights required some study of actually the data and the information that was available, wouldn't it?
It would.
So, can we presume that before you wrote the affidavit pointing out the oversights, you had looked at other materials?
If I recall correctly, the notice of additional testing from Mr. Burgess contained attached to it a whole report by him documenting why he thought there was an inadequate initial acquisition, why he thought the sizes were wrong. So I don't remember referencing anything beyond all the information that was contained in that. Now, whether that was combined by somebody else or not, I don't know. That's how it was provided.
Did you end up looking at the report of Ms. Gaffney and what had happened in the past with the download and search of Ms. Reed's Lexus materials?
If I'm remembering right again, I think Ms. Gaffney's report was also attached to that same singular file.
You learned that the defense expert, Ms. Gaffney, had downloaded data from chips, correct?
Correct.
And Mr. Burgess was asserting that there was information missing and believed that there was missing information from the chips.
Correct.
In that form, it's sustained.
It's stricken.
It's stricken.
My apologies. The conclusion Mr. Burgess had is that he believed there was missing information from the chips.
He did. He miscalculated the size of the chips.
Did you do any study to see if there was actually information missing from the original download?
No, I looked at the data sheets for the chips and then immediately realized what the error was. The data sheets specify a size in megabits or gigabits, and Mr. Burgess had written his report in the context of megabytes and gigabytes.
And then you asserted, or you took the position in your affidavit, that there should be no further chip-off, no further study of those chips, other than to ensure the amount of memory was sufficient.
It's not how I recall specifically what I said.
Well, let me read it because I don't want to try to malign your words.
Please.
Mr. Burgess' proposed protocol labeled reattempt chip-off acquisition is unnecessary because the file size of the acquisition performed by Ms. Gaffney already matches the expected memory storage capacity of the components.
That sounds accurate.
If you want to see this, I don't want to read from the document. If you need to see it for actually, just let me know.
That's fine. I trust your reading.
However, an acquisition may be conducted for the sole purposes of ensuring the contents of the memory chips have not been altered since the last testing by recording the checksum.
Yes.
Did it cross your mind at that point that there was important data in those modules that was not seen or recovered or obtained by Ms. Gaffney?
No.
Did you want to know when Mr. Burgess was looking for more data, more information, what he thought was missing?
He stated, I think, in his report or affidavit, I'm not sure what it was, but he stated what he thought was missing was there was a physical size difference. So he thought there was not corrupt data, but just missing chunks of data.
Log on information, you've heard of that. Ignition on, ignition off information.
Yes.
In an infotainment system. That's important information when you're reconstructing an accident, isn't it?
It could be.
Well, you read information in this case. It's pretty important in this case, wouldn't you say?
Yes.
And so you would not want to engage in that process without this pretty important information, would you?
Which process?
Of an accident reconstruction?
Sorry, so can you restate it, the whole question?
I'll
Yeah.
ask it again.
Yeah.
You said you have some experience in accident reconstructions.
Yes.
Don't you want all the data available? The more data, the better?
Generally, yes.
You wouldn't want to ignore data on purpose, would you?
No.
I mean, as a data analyst, the more data, the more you get to look at.
Yes.
And so the power log on information that actually has date and time, that's critical in an accident reconstruction, isn't it?
In some accident reconstructions. In some, there's no debate about when a vehicle was on or off, but if there is, then yes.
Not just on and off. The power log on and off gives you the date and the time that you can match with the text stream data, correct?
Yes, it does.
Because you know text stream data itself doesn't have date and time.
It can, this vehicle didn't. It can, but this vehicle did not.
This had a running time instead, like
That's
a stopwatch.
correct.
So this data that was not found during the initial process, that was critical data at the time.
I don't think prior to the process anyone knew that this particular Lexus infotainment system stored those key on and key off times.
Right, the only person that found this out was Shannon Burgess.
He found it in the process, but I don't think anybody knew in advance of this case. There was nothing out there about it. So to my knowledge, this is the first time that this specific data has ever been released into the wild.
But it was on the board there, if someone knew what to look for or got creative, they could maybe find it.
Yes, more so to your if got creative, because I don't think anyone would have been able to have the foreknowledge that there would have definitely been that.
Shannon Burgess did.
Objection. Sustained. I'll strike it.
And when Shannon Burgess went to obtain that data that everybody else overlooked or didn't know about, you went with him.
Yes.
So you had a process where he was going to now control the data and take the information that was left behind and remove it from the infotainment board, correct?
He actually never specified anything about the SD card in that initial notice. So it was a departure from his protocol, and it was a little surprising to me when I got there that the protocol was written with a specific focus on a number of other chips, and it became very apparent to me very quickly that the focus was not on those chips, and the focus was on this SD card that had previously been unmentioned. There was nothing in there about that prior to that.
Did it offend you, or were you impressed that he had found that?
I was a little confused because I went into it with an expectation. Generally, if we write a protocol, we adhere to the protocol. If we're going to deviate, we have a discussion about deviations. So I was just surprised. It's not customary to sort of shift out of nowhere. But other than that, I did not know what to think of it because I'd never heard of that.
Did you give any input? Did you have any knowledge about the SD card and how it worked?
No.
So when you watched Mr. Burgess remove the SD card, did you appreciate he'd have to engage in what you call reverse engineering?
He did not elaborate to me exactly what his whole process was at first. It sort of came out as time progressed through the first day in his office in Texas, and then I learned more as we moved to the second testing in Massachusetts. But he didn't explain it to me in one go.
Did you, at that point, understand or appreciate the relevance of the SD card relative to the infotainment system and what it could do as far as the amount of information that could then be available?
He never spoke throughout the 3 days at all about what kind of data he expected from the card or would be on the card or could be. He made no mention of the data.
Not what he said to you, but given your expertise, did it ever dawn on you the significance or importance of this SD card that was sitting in plain sight?
Objection. Sustained. You can ask it differently.
Did it ever dawn on you, as Mr. Burgess was recovering this information left behind, that there was something important or significant about it?
At the time, I thought it was a possibility. If you reference the initial work, a number of different memory components were identified in this infotainment. There isn't a singular memory chip. So if we're looking for data, it could be in any of them. So we found a new source of data storage, and there could be something there, there could be nothing there. It was unknown to me.
But it turned out there was.
There was.
Now, When you were watching Mr. Burgess work as an expert, if you felt like there was something inappropriate or he had some great oversight, you could write a report about that, couldn't you?
I could.
Did you ever write any report in this case?
No.
So you never wrote a report for your preparation of coming in and your data in the PowerPoint presentation, right?
Correct.
You never wrote a report regarding any of your observations of Mr. Burgess.
Correct.
You said that he didn't say anything. He spoke to you quite a bit during the process, didn't he?
He did.
He showed you what he was doing.
He did.
He explained to you what he was doing.
He explained the process. I think you had asked me earlier about whether he explained the data, and he didn't.
He demonstrated great proficiency, wouldn't you say?
He ended up with a successful acquisition of the card at the end of the process.
When you are considering all your equations, did you consider the timing information taken from the SD card that Mr. Burgess found regarding power on and power off of that car?
Yes, to the extent that he considered it in his own report. Again, I'm referencing his report.
But how about you? You're coming in here giving an opinion saying what's better or best practice or right. How about you? Did you consider, you personally, the one who's giving the opinions, did you consider the significance of the power on, power off data as it relates to all these times?
Yes.
Yes? Are you sure?
Yeah.
Okay.
I mean, I considered it. If that's the question is, did I consider it? I considered it.
Did you do any study yourself?
No.
Now, we agree, or you agree, that there are variances between different devices.
Yes.
So a Lexus clock that comes from the infotainment system is very common that it would be different than a different device like an iPhone.
Specifically this Lexus, I don't know if we can make the statement that it's common or not, because, again, this is the only time that I know of that this specific data has been analyzed. So I don't know the answer to that question.
Did you say on direct examination that variances between devices are common?
Variance between devices are common.
In a variance of 45 seconds, that wouldn't be remarkable on
No.
different devices. It's common in the industry.
Correct.
And in your business, that's an accepted amount.
I'm not sure what you mean by accepted. The amounts are what they are, and we have to correct for them. I've done analyses of clocks that are anywhere from completely correct, 1 second off. I've done analyses of clocks that are 25 years apart. So it's a wide range of possibilities.
I understand your point.
Yeah.
If you see, as an analyst, a 45-second variance or 30-second variance, that wouldn't shock you, would it?
No amount of variance would shock me, is the answer.
I want to ask you questions and go through your PowerPoint. And I want to ask you your specific opinions and how you arrived at certain claims that you've made.
Sure.
Okay? If we could put up Mr. DeSorga's new PowerPoint, 52525. You've made a modification to your PowerPoint?
Yes.
You've made an amendment to your PowerPoint?
Yes.
So there was something that happened, you received new information or new data, and you updated or changed your PowerPoint.
I did.
And that's an appropriate thing to do when you receive new information, isn't it?
Yes.
If you have new data, you don't want to leave it behind. You want to make the best presentation with the best data you can.
I'd want my presentation of the data to be as accurate as possible, so I included all the data.
And you would expect that from any expert, wouldn't you? If they received new information or analyzed new data and it was important, it would be an appropriate best practice to update the PowerPoint or information they're providing, wouldn't it?
Objection. I'm going to allow that.
I don't know if I would tell other experts what their best practices are. I would say, generally as experts, we do work that our clients ask us to do. So if we're asked to do it, we do it. If our clients say, hey, don't do that, then we don't do it.
Well, you like the phrase best practice on direct, so I'm just wondering if I can borrow that phrase.
Sustain.
Okay. We can turn to page 2. Now, this is taken from Dr. Welcher's report.
Yes.
And again, you did no testing whatsoever. You just read
I
the
did not.
report. Did you read all of Dr. Welch's data, the gigabytes and gigabytes of data? Did you go through it all?
Not every slide, no.
Not just the PowerPoint. I mean the actual massive amount of data in his study. Did you go through the data?
Oh, no, I didn't look at any of the data.
Did you ever speak to Dr. Welcher?
No.
And so when you are making assumptions on what he thought or how he analyzed, you're just guessing.
I am looking at what Dr. Welcher put in his trial presentation, and my assumption that's baked in there is that he's going to stand behind the things he says in a presentation, so I'm taking them at face value, but as being correct.
It's not a matter
I'm
of
not guessing.
It's not a matter if he's going to stand behind it. You don't know why he put something in here. You just see it on the paper. You don't know what his thought process was, did you?
To an extent, yes, because I understand how the exemplar testing by Aperture laid the foundation to align the key-on events in the infotainment to the Lexus VCH events.
When Dr. Welcher made his PowerPoint, do you know whether or not he was relying on 154 on Mr. O'Keefe's phone, stamp 154, as the end of the event as opposed to the beginning of the three-point turn, 1162-1?
Based on the math he uses, that's the implication. He puts a number on the screen that the only way you could reach that number is by making that assumption. So when I looked at the math, yes, that assumption seems baked into the math he did.
So this seems like it's baked in that he was assuming 154 on John O'Keefe's phone was the end of the three-point turn.
Not on this slide, on a later slide, but yes.
Okay. And you said that variances, 30 seconds, 45 seconds, they're very common when you're comparing two different devices, right?
Yes.
Okay. Turn to the next page, please. You point out two times for the jury, the Lexus event, 1162-2 ends 12:31:43, right?
Yes.
And that's based on the clock in the infotainment system.
That time is based on two things, the clock in the infotainment unit and the cumulative key-on timer in the text stream data. So it's a combination of two values.
Which is the running clock.
Correct.
Right. And that is compared or contrasted or coordinated with the log on off time that was found on the SD card. Yes?
Yes.
And without that SD card, we wouldn't have that time now, would we?
Correct.
Okay. 123209 isn't something you analyzed, but you just read in the report that that is information from Ian Whiffen suggesting or taking the position that was the last user interaction John O'Keefe had with his cell phone, 123209.
That's how I understand it. There was a phone lock at 12:32:09. I did not look into the underlying reports from where that came.
And you know those are two different devices, two different clocks that will have a variance.
Yes.
You mentioned trigger event, and you said that your preference is to, when you're doing times, to point it from the actual trigger event, and there was a little slap for emphasis to target you on that, right? The trigger event. That's not a standard practice or a protocol that is supported by any type of literature, is it?
It's the methodology I teach, especially in the class I teach on the analysis of heavy vehicle data. We have the exact same problem with heavy vehicles. They all have clocks on them. And so, in fact, I do a lot of clock adjustment on heavy vehicles relative to other sources. And the way I teach it, the way I'm not the only instructor, collectively the way we all teach it is we generally start the analysis at the trigger, which is not to suggest you have to do that. It's not wrong to do it a different way, but that would be let's call it the default methodology.
The default methodology, do you have any professional literature that says that is the best time to start the analysis?
Not literature. I mean, that's sort of my opinion, because that introduces the least amount of variables. Once you start trying to align events off of subsequent times, you just introduce more addition and subtraction or math you have to do. So it's easiest to do T0 and align everything from there.
If you're lining up the end of one event with the end of another event, it's more coordinated than if you take it from different spots, isn't it?
That could be a scenario where then you wouldn't use it. Right. Like I said, it's not the only way, but it's the default way.
I don't disrespect your method, but there are other ways to do it that are just as legitimate as the trigger now.
Absolutely. And that's why I didn't change the convention here. I used their convention,
So you're
apertures.
not suggesting that Mr. Burgess was being misleading by choosing the endpoint when he pronounced that's exactly the point he was considering, are you?
No.
And so the word cherry picking, you're not saying he was cherry picking, are you?
I don't remember the context in which I used the word cherry picking, but I don't think it was with respect to a trigger alignment.
So there's no legitimate professional basis of suggesting your way is better or worse than going from the front or the end of the event.
No.
So you're not offering criticism on that. So just so I understand.
Not criticism. I pointed out that it's not typical, and I pointed out not even to say specifically that it's not typical, because even that, to your point, might sound critical. I just want to be clear that I adopted their convention. It's not the way I would have done it, but I kept that convention consistent in my analysis, so I wasn't changing in the middle, trying to obfuscate what I'm saying.
I appreciate that. So if someone's looking end to end, you're not going to add 5 seconds. It's if someone went from middle to end.
Could you give me that?
Yeah, you were
a little
suggesting
different?
those questions about, well, since you're looking at the end instead of the middle, then you got to add another 5 seconds on. That's not really an accurate analysis if you're looking at a comparison from end to end. You wouldn't then add the 5 seconds to the time of the trigger because you're starting at the end from both devices.
Objection, Your Honor.
I'm going to allow it if you can answer it in that form.
It's going to depend on if you're doing an alignment with something that is a range of values, then you have to be consistent on where you're doing it. If you're doing discrete points, then that's just a single point in time. There's no beginning or end. It's just a single second. So the best answer I can kind of give is it depends on what you're doing.
Well, in this case, you're basing it off the end of the event, the end, not the trigger, the end, comparing it comparatively to the end of a different device. So you wouldn't just add 5 seconds just for the heck of it.
You would not add 5 seconds for the heck of it.
You see 12:32:09 minus 12:31:43, the middle line, equals 26 seconds. Isn't that in Dr. Welcher's slides before, let me phrase it more cleanly, before Shannon Burgess analyzed the data more closely on May 8th, in his May 8th report? Isn't this the exact difference in time that Dr. Welcher cites in his PowerPoint, 26 seconds?
I'll sustain it in that form.
Did you see, when you reviewed reports, that Dr. Welcher uses this exact number, plus 26 seconds in his report?
I got the number from the PowerPoint.
I'm sorry,
not the
PowerPoint.
report, but that is all of the numbers here on this slide are from Dr. Welcher's PowerPoint. And on the previous slide, I show that. So these are all just copied straight from that.
And you've labeled this John's interaction window.
I did.
Okay. Interaction window. Do you think it might be confusing when you use interaction window to make it seem like the event was limited to 10 seconds?
No, and that's not the implication there at all.
That's not what you're trying to say.
That's not what I'm trying to say.
Fair enough. Fair enough.
If I can clarify what I mean by interaction window is that there's
Please do.
a range of times that we end up with when we start running these adjustments. So we never land on a singular point of alignment. We end up, like I showed at the end, with 30 points. That's the window that I'm talking about. That's the window that I mean.
So if we could put up page 33 from Dr. Welcher's PowerPoint, just to illustrate the point you're trying to help us with. Like that a little for me. So this represents, you've seen this, right?
It looks familiar, like it's from one of his slides. And if I've seen it, I did not spend a lot of time digging into it.
Does this look like the 10 seconds of data that would be captured from a triggering event in a text stream data? Objection.
I want to see you at sidebar.
Okay, clearly Hank Brennan has decided to take I can't get him on his credentials and his education. So what I'm going to do is ask him questions in such a way that it implies that his testimony is the result of him being petty, not actually looking at the data in those reports, trying to go work backwards to figure out how this report came to its conclusions, because I'm salty that I didn't think about pulling off the SD card. Are you kidding me? At this point, it's not a good look, Hank. It's really not. You're um this Neat Noodle says, they were definitely paid for their testimony. So was this guy. The issue is that Aperture seems to be hired gun experts and have been accused of testifying on behalf of whoever hires them, no matter the actual results. The way that Aperture's testimony came across is as if, even though they were being paid for the work they did, okay, one of the extra pay, as it were, that comes from being called to testify. And they tailored their work product and their results so that they would get to that second tier of payment, which is the testifying. That's how it came across. It's just, they don't come across as credible. For example, we have Shannon 1N Burgess, who is saying, I did all this work and I even found something that nobody else in the world thought of looking for. Okay. I'm so smart and I'm confident in my work. But then I thought, let me go back for no reason, not to check my work, but to add work to it. Work that, depending on which part of the testimony you believe, was either requested by Brennan or not requested by Brennan, because he testified both ways. Everybody in the courtroom today is making money, including the jury. Everybody is being paid, except for the media is being paid, the judge is being paid, the attorneys on both sides are being paid. Everybody's being paid for for being in court today, except for just the regular witness or the regular people that are watching the trial. Okay, so it's not about the fact that they were paid. People should, if you do a job, you should be paid for the work that you do. It's about the way that they it's about the work that they actually did and how they arrived at the results that they did. That's what is in the question. And what this gentleman was hired to do was to go over and check the math respective to Dr. Welcher and respective to Shannon Burgess, because some of the calculations that Dr. Burgess did or Dr. Welcher did were based on Shannon Burgess's results. So that's all that happened. And it's, not this witness's fault that the people that the Commonwealth hired to do this job didn't do a good job. That's it. That's all. In this situation, it's no different than when you were in school and your teacher had the person, tell you to pass your papers back or pass your papers forward for either the person in front of you to check. and grade your work, or the person behind you to grade and check your work. That's essentially what this witness is doing. He's checking the math. And he had to go back and figure out, first of all, the math that was used before he could even check if the math was correct. And when he went to check all of the things, what he arrived at is that sometimes calculations were used, sometimes they were not, and that it wasn't consistent across the board.
So
That's it,
jurors,
that's
we're
all.
going to release you for the luncheon break. I took so long here to make sure that we could give you a nice full hour luncheon break. So we'll see you back here in an hour.
Please rise for the jury.
Sir, follow me, please.
Hang on, you guys. I'm just looking for something. Give me just a second, because I want to pull up this hearing that happened yesterday. All right. All right. So now we're going to move over to lunch with Lori, and let's listen to her last. Hold on a minute. What the hell? Now we're going to listen to the last hearing, pretrial hearing before her trial for the conspiracy to commit attempted first-degree murder in the shooting at Brandon Boudreaux. All right. Now, this comes from, as you can see at the top, Fox 10. For whatever reason, all of a sudden, this was cut abruptly. So I don't know why that happened, and there isn't anything like that came after that for me to play for you guys. So we're just going to play it how it was, and rest assured that this is perfectly fine. I promise you're not missing anything, really. That you're going to get the crux of all of it. So here we go.
Depending on the aggravator. This is not a capital case.
I know it's not a capital case, and in normal capital cases, you don't have an aggravation phase either, right? Only in a capital case.
Actually, you have a guilt phase, and then you have a mitigation aggravation phase.
Actually, have a guilt phase, an aggravation phase, and a penalty phase.
Right.
If the aggravators aren't found as a completely separate independent hearing, then there's no penalty phase.
So with the statute for this charge.
Okay, so basically this is what's going on. Okay. Lori Vallow Daybell Esquire doesn't understand the need for the aggravation phase in a trial. Okay. And here's the deal. She can't keep up clearly because this happened in the last trial. This is the way that Arizona does it. And Trina K is going to explain why it's done this way, okay, in a little bit, but we're not there yet. So the way that it works in the state of Arizona is you have the trial, all right? If the person is then found guilty, they have an aggravation phase, okay? So what that is it's a separate phase of the trial where the jury decides if there are any aggravators to the crime. And then comes the penalty phase. Okay. So if they find the aggravators, then those aggravators play into the penalty phase. Okay. So Lori doesn't understand this, doesn't agree with it. She big, huge mad. But if she had paid it, if she hadn't, she waived that phase her last trial. And the reason I think she waived that phase in her last trial is because she knew that there were going to be victims that would testify, and she didn't want that. So let's continue, but that's where we're at. Okay.
Only being the one statute, what are you getting out of the aggravation phase? I don't understand.
Well, first of all, the jury in the initial phase doesn't determine whether or not it's a dangerous felony, which they need to find. And then the aggravators, I think the state has a right to attempt to prove those to the jury, to offset any mitigation or to be weighed against mitigation at your sentencing.
And isn't that normally put together with the guilt phase? Like they would have that on the back page where it says the aggravators and the guilt?
No.
So are we going to have a whole nother aggravator phase in this case?
If the jury finds you guilty of the charge and the state wants to proceed with aggravators, yes.
And so we do not have to have a hearing to determine if there's probable cause for these aggravators?
No.
They're just alleged aggravators.
Correct.
And the grand jury never found probable cause for them.
Correct.
So you're saying that if the guilt phase goes through and they find you guilty, then you have an aggravator phase added to that?
That's what I said.
Okay. Hold on one second.
You have the allegation of aggravating.
Okay.
It was on my desk.
Your Honor, I would just like it to be on the record clear that the Rule 13.5 that I'm talking about is about non-capital cases. I know in capital cases, they call it a CONUS hearing, but this is for non-capital case?
Oh my God, Lori. I love how you're trying to get an explanation from a judge that you just earlier said was biased and accused of judicial misconduct.
It says under 13.5A, a defendant may challenge the legal sufficiency of the state's allegations by filing a motion under Rule 16. Is that what you're talking about?
Correct.
It doesn't say you get a probable cause hearing regarding the aggravators.
Well, I'm challenging the state's allegation of aggravators by asking for a 13.5 hearing on it.
So the state's aggravators that they've alleged is that the offense involved the infliction or threatened infliction of serious physical injury. The offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of the crime, specifically a gun. The offense involved the presence of an accomplice. The offense caused physical, emotional, or financial harm to the victim, or if the victim died as a result of the conduct of the defendant, caused emotional or financial harm to the victim's family. The next one is the defendant was previously convicted of a felony within the 10 years immediately preceding the date of the offense. This one's really not very specific. Any other factor that is relevant to the defendant's character or background. So if you were found guilty by a jury of conspiracy to commit first-degree murder, which of these aggravators do you think there's not legal sufficiency for a jury to determine? Because they seem pretty inherent in the charge itself, except for your prior convictions, which, are you saying you don't have the prior convictions within 10 years?
No, I'm not saying that. Which of them don't qualify for the jury to make that determination?
That's the
No,
question
you're
he's
asking for me to
asking
make a
you.
determination that there's a legal sufficiency for them to go to the jury.
Correct.
So I'm asking you, if you were found guilty by a jury of the charged offense, which of those aggravators that have been alleged by the state do you think there would not be legal sufficiency for? Because as I look at those aggravators, most of them are inherent in what you're being found guilty of. Again, if the jury found you guilty. For example, the first aggravator, it involved the infliction or threatened infliction of serious physical injury. The allegation is someone shot at the victim. That's the threatened infliction of serious physical injury. So it seems like that allegation, there's sufficient evidence for a jury to decide whether that's an aggravator. The next one, the offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of a crime. Again, if you were found guilty of the charge, as the state has alleged, the jury would find that a gun was used. So that's a separate aggravator, again, that would already be determined by the evidence. The state has alleged an accomplice, your brother. If the jury were to find you guilty as charged, again, my understanding of the state's allegation is your brother attempted to shoot Mr. Boudreau. You weren't in Arizona. So if the jury found you guilty of this charge, it would mean they found you guilty as an accomplice. If someone shot at the next aggravator, I don't think it's a leap for a jury to presume there's some sort of emotional harm. So I'm struggling with what legal sufficiency you think is lacking for a jury to make those determinations. Again, only if the jury found you guilty of the charge that you're charged with.
I understand, Your Honor, but in 13.5, right, whether capital or non-capital, the state has the burden to establish probable cause, the legal sufficiency of an amended indictment. This is an amendment. This didn't go to the grand jury. Is that correct?
Right.
So now I have the right to ask for a hearing so the probable cause can be found for these aggravators ahead of time.
So you're confusing two things.
Okay?
All right. 13.5B talks about amending the charge or the indictment. Okay, your charge is conspiracy to commit first-degree murder. It's not, your charge is not being amended. The grand jury did find probable cause for that charge.
Correct.
An aggravator is not an amendment to the indictment.
It's a whole nother allegation. It's a whole separate allegation.
No, it's not.
Difference between an aggravator and changing the charge that you're.
Look here, Lori. You need to think of, let's put it in a term that you would understand. Okay? Green chili chicken enchiladas. Okay? You put the chicken in the tortilla, you roll it up, you put it in the pan, right? It's an enhancer. It's only green chicken chili enchiladas, right? If you used green chili sauce. Okay? It's an enhancer. It doesn't change the fact that you're making enchiladas. Okay? It just changes the type of enchiladas. It's an enhancer. All right? So the jury then needs to find that you've had all of these aggravators so that during the sentencing phase, right? The aggravators are established. The jury has found this aggravator, that aggravator, all the aggravators, whatever it is, right? And during the penalty phase, your attorney, you, would then use those aggravators as a guideline for the mitigators. You freaking idiot.
You're charged with.
It's not a separate
If the
charge.
state were to change the charge that you're charged with, for example, if they changed it from conspiracy to commit first-degree murder to conspiracy to commit second-degree murder, there'd probably need to be a new probable cause finding.
Correct.
Secondly, as to the allegation that it's a dangerous offense, the grand jury did make that finding because that allegation was included in the indictment that it was a dangerous offense. So there has been probable cause as to the dangerous factor.
Okay, if that is the case, then why isn't that found in the original guilt phase as opposed to having a whole nother aggravation phase after that, as if it's a capital offense? Because there's one statute,
Well,
there's one sentence, there's no arguing the sentence, and if it's already a dangerous crime, then there's no reason to have an aggravator phase.
What do you mean there's no arguing and there's one sentence? I don't understand what you're saying.
There's one sentence for the charge. There's only one sentence for this charge. And if it's already classified as a dangerous charge is what you're telling me, right? Because it's conspiracy to commit first-degree murder, that's a dangerous charge. The jury has already found that it's a dangerous charge. Then what is the aggravator phase finding? If it's already a dangerous charge and there's only one sentence.
Does the state want to respond why the state wants to proceed with aggravators?
To start with, the jury is not going to make a finding of dangerousness as part of the guilt phase per case law. That's not permitted. So the jury has to make a separate independent finding after they find the defendant guilty. The dangerous finding will include the use of a weapon and or the intentional infliction of or threatened infliction of physical injury. So at the very least, the jury has to make a finding as to dangerousness.
I agree about dangerousness. I guess the question is, why does the state want to prove up aggravators if the jury finds the defendant guilty of the charge as a dangerous offense, given the sentence?
Your Honor, in all honesty, you could ask me this, 10 years ago before Blakely was put out. As case law changes on appeals, I've had to come back before and redo a penalty phase, an aggravation phase, and re-impanel a jury. So I prefer to, since we're already going to have an aggravation phase for the dangerous allegation, to add on the other factors, and therefore I don't have to ever worry about this coming back on appeal later.
All right.
How is it not already found to be dangerous?
Oh my
You just said that
God.
if they find me guilty, then it will be dangerous.
I didn't say that. I said if they find you guilty, then they make a determination whether or not it's dangerous. Now, I think what I meant was when a crime involving a weapon is used, whether it's a gun, usually it's sort of a foregone conclusion that if the jury found you guilty of conspiracy to commit first-degree murder by someone shooting at another individual, that they're 99.9% likely to find that it was a dangerous offense. But it's something the jury has to do.
Right, but usually aren't aggravators for sentencing? What other purpose does it serve in this case with this charge, with one statute? You can't give me less time, you can't give me more time, you can't do anything else except for, it's one statute.
I guess the prosecutor's saying she wants to cover her bases in case there's some change in the law and what a jury has to find or not find for purposes of sentencing. And they have the right to proceed with aggravators. All right, you're right in that if you're found guilty of this charge at this level, you get one sentence. But who knows what a court of appeals would do in the future if aggravators or things weren't presented. I don't know that what would be presented at a sentencing phase from your side or from the state's side, but it sounds like the prosecutor's wanting to cover her bases.
So then I'm not entitled to a hearing before trial starts to find probable cause for these aggravators that were not taken to the grand jury.
Let me explain something to you, Lori. Okay? The probable cause for these aggravators to be used is inherent in what you're charged with. You are getting a hearing for the aggravators. Are you suggesting that you should change the aggravators? There should be no aggravators? What is it that you're actually trying to do other than be a pain in the butt? Because really, that's all the argument is here. You're making zero sense. You don't understand. Your rights are being protected and your due process is being ensured, even though you've accused both the prosecutor and the judge now of not doing that. Get bent. God, you're ridiculous.
Initially?
All right,
I'm asking.
I'm trying to explain it to you. The jury did find probable cause that this was a dangerous offense. It's included in your indictment. So they did find.
They didn't find these specific aggravators. Being a dangerous offense and these specific
Can I finish
aggravators
what I
are
said?
different,
What I was saying.
right?
I didn't interrupt you. Can I finish? Okay. The jury did find probable cause on the dangerous allegation. All right. You're not entitled to a probable cause hearing on the other aggravators.
When is conspiracy to commit murder not a dangerous crime?
When someone says they're going to choke someone to death and they don't actually do it, it's not a dangerous crime.
So,
No dangerous instrument or deadly weapon was used.
so because some instrument may or may not have been used in this crime, it's considered a dangerous crime?
Right.
And these aggravators that talk about something totally different don't have to be found after that it's found a dangerous crime?
Correct.
And that is supported by case law?
Yes.
So that what? When you go to appeal, you can't say it was a non-dangerous crime?
All right. I don't know what to tell you. All right. There was a case that came out about 15 to 20 years ago now called Blakely that said a jury had to determine aggravating factors. Okay. Before that, a judge determined aggravating factors at sentencing. Now a jury has to determine it. The reason it's not done in the guilt phase is we don't want the jury to confuse the issues. We want the jury to decide first whether someone's guilty or not guilty, whether the state has proved its burden beyond a reasonable doubt. We don't want them to start thinking about other things like aggravators if they have questions about whether or not the person's even guilty. It tends to confuse the jury and confuse the issues for them. So that's why we do the aggravators in a separate hearing. First, you want to make sure the state has proved its burden beyond a reasonable doubt as to your charge.
But these specific aggravators that they allege, right, the ones that you just went over, you're saying that now after you're found guilty of a dangerous crime, that they're going to go back in, and what is the purpose of that? How does it change anything after that?
I don't know how else to explain it to you. So do you have other issues that you want to bring up today?
Yes, but I would like to finish this first. So are you denying my motion to have a hearing on this?
I'm denying your motion to have a probable cause hearing as to the state's alleged aggravators.
Okay, so you're denying my motion to have a 13.5 hearing on these alleged aggravators?
Correct.
Before trial starts?
Because you're not entitled to one.
Okay.
13.5 says that you're entitled to a probable cause hearing if they amend or change the indictment.
Yeah, okay.
This is not an amendment of the indictment?
No, an amendment to an indictment adds extra charges or changes the original charge. You Nimrod. Jesus.
It's not. There's a difference
It's an extension of the indictment. It's not in the indictment.
It's a difference, okay, between an aggravator and changing the charge that you're charged with. Changing the charge that you're charged with is an amendment to the indictment. For example, if you were just charged with conspiracy to commit first-degree murder, all right, but the state didn't allege with the grand jury that it was a dangerous offense, you'd be entitled to a probable cause hearing as to that dangerous allegation because it's changing the charge and it's changing the sentence that you would be getting. These aggravators.
That's exactly my point. How does, after the fact, these aggravators, if they're found, what do they do to change the charge or change the sentence or change anything?
Probably nothing in reality. You just said it. They don't change the charge. So you're not entitled to a probable cause hearing.
Okay, then I don't want to have an aggravation phase either.
Well, you can
How
not.
are you entitled to that? And I'm not entitled to a hearing on probable cause, but you're entitled to have an aggravation phase.
Well, if you don't want to attend, you don't have to attend. What else?
All right. Something dealing with trial is that I've asked several times for headsets for my advisory council. I know that's been an issue that you said we can only have 5 headsets. Is there some way we can do that? Because it's very difficult for them to advise me on things when they kind of don't know what's going on.
If you need a break to consult with your advisory council, we can do that. I can only give so many headsets.
You said you were going to check into that. Is that something that
They
you did
said
check
they-
into and
they
there's no
can't-
more available headsets?
They can't do more than 5 on that particular system or network. that they have. I need my court reporter to have one so we can do the sidebars. The state's only getting one. I get one, so that leaves two for you. Whoever you want to have besides yourself, you can choose one of your advisory council or your paralegal.
But you're forcing me to choose between the people that are helping me?
Lori, do you understand what your role in this situation is? Not only are you the defendant, but you're also the attorney, okay? So if you have a headset, that means the attorney has the headset, okay? Plus you get one other person, which if you were a licensed attorney, okay, would be your co-counsel, all right? Or your attorney and you, okay? So this is completely fair. You're the attorney in this case, you big dummy. Shut up. What are you you're arguing about? Why do you even need people to help you? You're the attorney.
Sure.
Okay.
Technically, I don't know I even have to do that. You represent yourself. You're considered your own attorney. You don't even have the right, the right to consult. I shouldn't say that. You have the right to consult with them, but it's not a necessary thing. Because you are acting as your own attorney, you're expected to proceed as your own attorney. They don't have an affirmative duty to even give you advice under the case law for being an advisory council. The fact that they do is probably helpful to you, okay? But you chose to represent yourself. It means you are supposed to act as your own lawyer.
You appointed them and assigned them to me. I did not ask for them.
Okay, yeah, I did, in case you decided not to represent yourself so they could step in at trial.
Okay, well then is an alternative that we could do sidebars at the bench so that they could be involved during
I
that
think it
time.
depends on the complexity of the question. If it's a simple jury question that, like, for example, can we have a copy of the police report? The answer to that is always no. So I think I'll have to take it on a question by question and issue by issue basis. So if it's an issue where we need everyone at the bench, yes, we can do that. But if it's a simple, quick response that we can do with the headsets, we'll do that.
Okay.
By the way, Lori, he appointed them to you to be helpful to you. They're not required to actually help you, okay, because you're acting as your own attorney. And now with the first comment that you made, that you didn't even ask for them, well, then what do you care if they have friggin' headsets or not? Why is it that you can't relay to whoever doesn't have the pay, whoever's turn it isn't to have the headset? Okay, why can't you relay to them? Or how about this? Why don't you figure out who's best suited to help you on your team and let them have the headset? Jeez, Lori, you suck. You're so annoying.
I have
Shut
one
up.
more issue.
Oh, you,
Go ahead.
Lori,
Okay.
stop right there. That's a lie right there. You don't have one more issue. Okay. Lori, you have the entire subscription at this point. Okay. But let's hear your one more issue.
Seeing as how things went in the last trial.
Oh, here we go.
My question is, what does the state intend to bring in from Idaho so that I can prepare my questions without being accused by you of opening the door?
No, 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 no.
Most of these.
No, 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 no. Now you stop right there. Okay. If you were a real attorney, you wouldn't even be asking this question because you would understand how to question the witnesses on cross that the state brings in so that you don't open the door to testimony coming in about your other crimes. Okay. If you need case law example, go watch the Murdaugh trial and watch how Griffin opened the door, and he is an attorney. Okay. Stop it. All right. Nobody accused you of opening the door, you big dummy. You were warned so that you didn't open the door. And instead of saying, this is the most, instead of doing what you should have done, right? which is to say thank you to the judge because he helped you out, right? You are willing, like a bull in a china shop, to go full speed ahead. And somebody during the lunch break got a hold of your ass and stopped you, much to my dismay. I wanted you to open that door. But be very clear, Lori Vallow Daybell Esquire. Nobody accused you of opening a door. You were warned. That's very different. You were cautioned. Shut your clown ass up.
Almost every witness has testified in my Idaho trial, and I don't want to be responsible for doing that. So how are we going to handle that?
Well, I will tell the prosecutor to make sure a caution is given to each witness that no matter what the question is, that witness should not think it's a question that would require an answer about prior testimony or prior proceedings. State agrees, right?
Yes, Your Honor.
I guess they can be further advised that if they think you or the state is asking a question that calls for that sort of answer about prior testimony or a prior proceeding, that maybe we should take a break.
Okay.
All right. Anything else?
That was it.
You never say
All right, we'll
thank
see
you,
everyone.
you ungrateful puta.
She said if both parties use all the jury,
Hold on.
that also means that we can bring in the survivors whatever time tomorrow, since they haven't put out a message yet, or excuse everybody.
Okay, so I'm being informed that the jury commissioner said if the parties stipulate to not bringing in any jurors tomorrow, we can do that. Remember last time, though, we screened whatever number we had. A few of those people didn't show up, even though they were informed they needed to show up. So we have 66. I think because it's a shorter trial, we don't necessarily need 4 alternates, but maybe we should.
Let me just say this. This is the perfect level of advice. Tony says, maybe instead of chasing other people's husbands, plotting to murder your children and husband, and rewriting the Bible, you should have watched a little more the Ward case studies, Lori. See, if you'd have been over here watching trials with us, none of this would have happened. Jezebel. That's what you get. All right, now, I'm given to understand that Nate did a, let me see if it's in here. Hold on. That Nate showed, here it is. Hold on a second. Did he show it uninterrupted though? Let me make sure. Yeah. Okay. So shout out to Nate, always the consummate professional, coming in clutch for us over here to watch during this lunch hour. All right. We are going to watch now Lori's hearing where she is accusing the judge of hold on, judicial misconduct. Here is the link to the live that Nate did, because it's an hour and we're only going to watch a tiny part of it, but I would always advise watch the whole thing. Watch all the things that Nate puts out because they are very good. I watch all the things. I fixed it for you, Tony. Don't you worry. I got you, boo. I pulled a Shannon one and Burgess. I just did my own work. Nobody asked me. Nobody requested it. I just volunteered. All right.
Good morning, everyone. The court calls CR 2022-00124201. This is State versus Lori Daybell. Appearances, please.
Trinity Kay on behalf of the state, and for the record, the victim is appearing virtually.
Thank you.
Lori Daybell for the defense. Pamela Hicks, Advisory Council.
Thank you. There was this got set very quickly. There was a media request that I became aware of in passing, literally on my way over here. I don't have a written request. I have not read all my email because I've been on the bench this morning. Do you want to make a record with regards to the media request from the state?
No, Your Honor.
Okay, from the defense? No. Okay. I don't see anyone here. I thought we would address it on the record, but I don't see anyone present from the media. Okay, I assume there's no objection if they come in. Ms. Kay?
No, Your Honor.
Ms. Daybell?
I always object to them, yes.
Oh, you object to them?
Always.
Okay. Is there anything you wanted to put on the record?
No.
All right. My thought is if they come in, we can address it. All right. The court's, this is the oral argument on Ms. Daybell's motion for change of judge for cause. The court's in receipt of and has reviewed motion to disqualify judge. This was filed on May 20th, and the state's response to defendant's motion to disqualify judge. Ms. Daybell, I've read your motion. In summary, the way I read it, you're asking for the court to remove Judge Boreski for cause under Rule 10.1. You cite several reasons, specifically that he's denied various motions. You mentioned facial expressions. You mentioned a belt and his not allowing you to remove it. You assert that he violated your speedy trial. There's a mention of religious persecution and an allegation of personal bias. So you're going to get, and then the state's response is that simply that the defendant does not establish judicial bias, appearance of bias, or fundamental error. Of course, under Rule 10.1, the court is evaluating whether or not Judge Boreski can be fair and impartial and whether he can conduct a fair and impartial trial in this matter. So I'm aware of the allegations. You'll have the opportunity to go first, then I'll allow the state and to address the court, and then you'll have the last word. Whenever you're ready, Ms. Daybell.
Okay. I did file this motion in this.
I'm sorry, can you pull the microphone? Sorry, I can hear you.
Sorry. I did file this motion in this affidavit after several attempts to. I made an oral motion with Judge Boreski and asked him to recuse himself because of the bias and prejudice that I had seen during our last trial and throughout the whole entire time that he has been the judge over all of these cases. And he refused to do so. So I thought I needed to put it in writing and put all my points in that I felt like were causing him to be biased and prejudiced against me, and that obviously you've read it, so you've seen all the different things that I put. There was an actual comment during trial when I was cross-examining one of the witnesses where he said to me directly after an objection from this state that I was comparing myself to biblical prophets, which I absolutely was not doing, and I didn't even realize it until someone showed it to me on the FTR afterwards that he had even said that, because I was in the middle of questioning the witness. And so there's several times that he made comments directly to me. I tried to address this with him directly in our last hearing on May 14th, where I asked him why he had denied every single motion that I had ever filed in the last year and a half. And he said that my motions had no merit. I asked him if my prior defense team, that he denied all of their motions, that they had no merit as well. And then I asked him, my prior defense team before that, all the motions they filed were denied, and did they have no merit at all either? And I asked him again if he would recuse himself from this case so that I could get a judge that was impartial and fair and have a fair trial. That is my right, my 6th Amendment right and my 14th Amendment right to have a fair trial, an impartial trial, and not a judge who has some kind of bias against me.
Lori.
All right. Anything else?
Hold on a minute. Sorry, Your Honor. Lori, you simply saying that the judge has bias doesn't make it so. This would have been your opportunity to cite specific examples other than this comment, which you took completely out of context. You objected, okay, to, excuse me, Trina K objected to your question of the witness about, have you cited some specific people that were translated beings, okay? And the question, the substance of the testimony was you saying that you felt like you were this translated being, and so you no longer had to atone for any shit you did here on earth, okay? All the judge said, which is exactly what you were doing, you were comparing yourself to a biblical figure. You asked the witness, have you not ever heard of so-and-so from the Bible or such and such from the Bible? Okay. You said that you're the same. You're both those people are translated. Yo ass is translated. So you were comparing yourself. Shut the front door. That's not what happened. He wasn't showing a bias. He wasn't showing anything about religion one way or another. He was actually agreeing with you, and he allowed it in. He actually overruled the prosecution's objection and ruled in favor. That's not bias, okay? Again, you can't just say, oh, it's kind of like, this is the whole problem with you. You think you saying it makes it so. Okay. You think that sitting in that courtroom are a bunch of Melanie Gibb, Melanie Pulowski, formerly Boudreaux, a bunch of Zulema Pastenises and a bunch of Alex Coxes who are just going to sit around and hang on your every word and take it at face value. That ain't how the real world works, shug. Okay. If you're going to make an allegation, you need to cite a specific example. Okay. Which of course you haven't you don't have any. So this is what you do. And let me just say this. You could be in front of the Judge Bevs of the world, or the actual Judge Bev. Then you'd know what bias is. Idiot. Shut up, Lori.
Thank you.
Judge, just the prior defense motions almost all exclusively dealt with motions to preclude the media. Judge Boreski applied the appropriate law in finding that the media had a right to be present and tried to limit it by saying things like they couldn't focus on the defendant's papers or things like that to mitigate any of the concerns by the defendant. All of the defendant's motions that she has filed have been without legal basis. They've been appropriately ruled on, and the state's motions set the state as one have been ruled on based upon, again, legal basis. So the fact, as the court is well aware, that the defendant has had all of the motions ruled against has no basis for bias if they're all been ruled on based upon the rules of law and the rules of evidence. So we see nothing that the defendant has provided here that would rise to a level to preclude or recuse Judge Boreski from this case.
Thank you. Ms. Daybell, you can have the last word.
Yes, also, along those lines, Your Honor, that's one thing that I asked Judge Boreski, is that he has denied all these motions with no finding of fact and no conclusion of law. I said, what is the finding of fact and conclusion of law? These are just denied, 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 denied. He's also denied several attempts for me to try to ask the state for discovery that he's just denied outright. And then as I keep filing more and more, as I find out what we don't have and I ask for it, I'm continually, even to last week, getting brand new discovery with brand new Bates numbers, stuff that they realized they never even had before that hadn't been turned over. And I've been asking Judge Boreski for these items for a year and a half. And I'm getting them 1 week before trial. We start picking our jury today. We're supposed to be doing our strikes today. And along those lines, I had this motion about
Hold on a minute,
the
Lori.
REC.
Shut up. Hold on. Let me just say this. Let me say this. You are filing motions with the court, right? Requesting specific items of discovery. And I've watched a few of these go down. And you're saying that now you're getting that discovery. What's the problem? All right. The judge, when the defense or the state makes that type of request, the judge is going to ask the other side. And correct me if I'm wrong, Lori, don't bother because I'm not. What you were asking for in at least one of those motions does not exist. Period. The end. What is he supposed to do? What is he supposed to what? Make the state produce evidence that doesn't exist?
Belt that I had asked him about since we went through this whole trial, and there was times.
Oh my God, if you say anything about this damn belt again, this is what did you even read the response from the jail? What they said was, if there's no belt, then we could put extra officers, but we don't want to do that. We recommend the belt. That's what they said.
When the belt didn't fit around me, so it fell out of my clothing. We had to stop trial and I had to go fix it. And that is what MCSO recommended, that if that was too burdensome, that they would put an armed guard in the back. And because of the media that Judge Boreski has let into every single one of the hearings and the trial, that they already have an armed guard back there. So it wasn't going to cost the state any more money. It wasn't going to cost anything if he just had them remove the belt and went over the security that the MCSO actually recommended. Every single thing that I asked for has been denied. I feel like he does have a personal bias against me, and all I'm asking for, I went through a whole trial with him, even thinking he was biased against me before the trial started. I filed for a new motion because it came to our attention through the media. The media sent Judge Boreski a clip of one of the jurors saying that he found out about my prior convictions beforehand, before his deliberations. And this is the same exact juror who was brought in twice during trial by Judge Boreski, where he had to admonish him for, one, being on his phone, and two, talking to one of the other jurors about the case. And now he's saying, well, he went on another media thing and said that he took it back. He took back what he said, so I'm not going to give you a new trial, and nothing was done about it. He refused to call them in and have a hearing and put him on the stand under oath and ask him if he found out this information prior to deliberations. It was very confusing, and everything is just outright denied. I want to go to trial. I want to have a fair trial, as fair as possible. I don't feel like I can do that with Judge Boreski, and I would like to be appointed a new judge who wouldn't know anything about the case and be fair and
Lori, how can a judge preside over a trial without knowing anything about the case? That's an impossible task. Okay. First of all, okay, you're going to file motions. All right. Now, what do you suppose those motions that you're going to file are going to be about? Are they going to be about the Karen Reed trial, or are they going to be about your case? Of course, a judge is going to know some things about the case. There's a whole hearing. There's for the evidence. It's an evidentiary hearing where both sides say, hey, we think this should come in. We don't think this should. And there's arguments back and forth. So inherently, a judge is going to know some things about your case. Listen, lady, I know you're big-headed to think that you're like the sun and the whole freaking world revolves around you, but it doesn't. Okay? Judge Boreski has been more than fair. He's been fairer to you than I would be. If I were the one in charge of that clicker that controls your stun belt, you'd be getting shocked at least 5 times. At least. And one, I might just accidentally on purpose fall asleep and just get a heavy thumb and just hold it. Ridiculous.
as impartial as possible. Thank you.
Thank you.
Thank you. I've considered the written motion and the response, and certainly your comments today from both sides. Ms. Daybell, I find that the fact that you disagree with Judge Boreski's substantive legal rulings is not a valid basis under Rule 10.1.
Uh-oh. I can see the steam rising. That's the thing. You make an accusation. You don't have any proof. You just disagree with his application of the law. And so now he's all of a sudden biased. Shut up, Lori. That's what you get.
to grant your motion and give you a new judge. The standard in 10.1 is, has he demonstrated he can't be fair and impartial? And the fact that his rulings have not gone your way is not a valid basis to suggest that he can't be fair and impartial. Unless there's some other allegation of bias that's been demonstrated, I don't find on this record that it has been demonstrated. I certainly understand your frustration with the way that the rulings have come out, and it sounds like the way that they came out with prior counsel, but the things that you have cycled through at length in your motion to disqualify, I've considered all of them. Whether or not he should have ruled differently, for example, the example you gave with the juror, or with making findings of fact and conclusions of law in writing, some of the issues you have, if you have concerns about his substantive legal rulings, you can file a motion to reconsider, or you can take them up on appeal. You can file a special action. You have a number of legal remedies at your disposal where you can make those arguments, but they're not grounds under Rule 10.1 to get a new judge. So I am going to deny your motion. Again, as for your concern about his substantive legal rulings, you can address those concerns in a different way, but it would not be under a 10.1. And on this record, I don't find that he's demonstrated that he can't be fair and that he can't be impartial. I also wanted to address the comment that he made that you illustrated. That comment alone doesn't demonstrate that he can't be fair and impartial. I'm not exactly sure of the context where he made it, but it sounds like he let you ask a question with regards to religion, and that was his decision. But again, I don't think even that demonstrates that he can't be fair or impartial in this case. All right, so I'm denying the request to disqualify Judge Boresti under Rule 10.1. Is there anything else from the state?
Peace out.
Anything else, Ms. Daybell? Nope. Thank you. We are adjourned.
All right. So
peace out. That's it. That's all. That's what you get, Lorvie. You can't just, run around out here just saying, oh, so-and-so did such and such. No, that's not how it works, Lorvie. You have to prove the allegation. And guess what? Since you made the allegation, guess what, Shug? Burden's on you, and you didn't do it. Nope. Why don't you save everybody a whole lot of headache? Why don't you save Brendan Boudreau the pain of having to testify in that trial? Why don't you just plead guilty? It changes nothing for you. You get your ass right back onto prison where you belong. That's it. That's all. Easy peasy, lemon squeezy. All right, you guys, I need a human break. We got about 15 minutes before lunch they're due back from lunch. So just give me a moment, okay? And I will be there. All right? BRB. All right, you guys. So I have a little bit of news. On my way back from my human break, my daughter texts me and has needs me. So I am going to cut it short for today. We only really have, when they get back at 2, we'll only have, a couple of hours. And let's be honest, it's going to be a couple of hours of Hank Brennan. Blech. Who wants that? Anywho, okay. I'll be on this weekend. We'll do something. I don't know what I'm going to do. I know I definitely am going to be over at Allie's, but also I wanted to let you guys know. And also, before I forget, let me say hello to the chicken lady. It's good to see you, babe. So, for scheduling, okay, I am going to stream the Lori Vallow Daybell Esquire trial. This is how it's going to work. In the morning, I will start with Karen Reed. We will go all the way through the day with Karen Reed, which actually puts us in a great spot for streaming Lori because there is a delay and there's a delay coming back from lunch and all of that. And we'll be able to skip all the way through that and be fine. So that's how it's going to go. There'll be a little time in between the 2 streams, and then we'll, I might put like a 30-minute start, 30-minute break in between the 2 streams so that everybody can, reset and do all those things. And that's how it's going to work. So that way it works for me too, because I think it'll be easier. And sometimes after I've streamed all day, the last thing I want to do is then stream at night. I'm tired. This will keep me from doing that, number 1. And number 2, as you guys know, Chicky Nuggy Pot Pie Esquire's lung biopsy is the 3rd of June. Okay. And because the kiddos will be at the hospital with her, they need somebody to stay at the house. And this will help me be able to get done with streaming Lori's trial and be over at her house. So I'm not walking around, going back and forth in the dark. So it keeps me safe too, because I'm snack size and I can get snatched. Nobody's going to snatch me. Let's be honest. If they did snatch me, they'd bring me right back. So thank you guys all so very much for being here. I appreciate it so, so much. If you haven't done so, please do me a favor and give your girl a thumbs up on the stream. I would appreciate that too. Or a thumbs down if you're just like, bruh, we can't take you no more, Bendy. Today was too much. They'd bring me right back, especially with that mouth. Rachel, you know it, because I'd be asking questions. Is this your first kidnapping? Is this the first time you snatched somebody? What are we going to do? Hey, on the way out, can we stop somewhere? I'm thirsty. I need to go potty. There'd be all kinds of things. It'd be too much. Yes, Tuesday, Tess, Tuesday. So if everybody could just harness all of their good juju and send it to the little Chicky Nuggy Pot Pie Esquire, I would so much appreciate it. And again, like I said, thank you guys for being here, because doing this is a great distraction from focusing on something that's completely out of my control. And I really appreciate that. So thank you all so very much. Thank you for being here. I will see you guys this weekend, definitely on Alex Erickson's channel. She's got a charity stream that she's doing, and I'm sure I'll be on my channel at some point for something. All right. You guys have a great rest of your day, and I'll talk to you later.